Good afternoon, all. This is Judge Goldblatt. We are on the record in Re Allegiance Coal USA Limited, which is case number 23-10234. We are proceeding this afternoon by way of Zoom. As a result, I ask that folks that counsel mute your microphones unless you are addressing the court, that everyone introduce themselves for the record each time you address the court. And then finally, my own preference is that folks generally leave your cameras off unless you're either addressing the court or wish to be heard, because I find it helpful if folks turn their cameras on as a way of signaling that they'd like the opportunity to be heard. So with that, I understand we've got a bit of an afternoon ahead of us, but why don't I turn it over to counsel to the debtor to take us through the agenda.
Good afternoon, Your Honor, and may it please the court, Matthew Harvey from Morris Nichols Archman Tunnel on behalf of the debtors and debtors in possession. I'm joined today in the office, Your Honor, by my colleagues Eric Schwartz, Andrew Remming, and Paige Topper, and I believe our colleague Robert Denny's on the Zoom line as well. Also on the line for the debtors are Mr. John Ronke, who's the debtor's Chief Executive Officer and First Aid Declarant, and the debtor's Chief Financial Officer, Chris Walker. There's Mr. Ronke there, Your Honor, so you can see it. And the debtor's Chief Financial Officer, Chris Walker. We expect to offer testimony from each of them today, either through the form of declaration or live direct testimony, Your Honor.
Okay.
I wanted to start, Your Honor, after those introductions, first by thanking Your Honor and Your Honor's chamber staff for accommodating us today and scheduling this hearing. We endeavored to get papers on file as quickly as possible, get them over to your chambers, and as always, your staff has been very accommodating, and we thank them for that. Next, Your Honor, I want to start with a little bit of an atypical brief overview for a case like this. I don't want to belabor the record, and that's really out of practicality. We filed the declarations, we filed the motions. They set out the circumstances, the quite emergent circumstances under which the debtors find themselves in front of this court. We do have payroll due tomorrow. In order to make that payroll, we need 3 forms of relief that we're requesting before the court today. That's cash collateral, first and foremost. We have the money to pay employees, an employee wages motion so that we have authorization to pay the employees, and then a cash management motion so that our banks have comfort that they can allow us to use our bank accounts to make those payments. It's 2 p.m. on the East Coast, Your Honor. This company has operations in Colorado, which is Mountain Time, and operations in Alabama, which is Central Time. We have a very slim window here with any hope of making that payroll today. So I'd like to dispense with the normal sort of overview of the company, assuming Your Honor has read everything, and sort of get right into it, if that's okay.
Certainly. Look, and I've read the papers, and so to the extent you want to, things other than the use of cash collateral are uncontested, I'm happy to address those as quickly as we can and get to where there's a dispute. But that's, again, I understand it's the first day, and to the extent someone wants to raise objections to those other motions, I'm happy to hear it. But why don't we do what's easy first and then turn to what's harder?
Okay, actually, I think, Your Honor, we'd like to start with what's harder, because the other motions, we don't have money to pay employee wages if the cash collateral motion.
Okay, all right. So just as a matter of orderly procedure, it seems to me, to the extent we can get a joint administration motion entered, it seems like that would be appropriate unless that's controversial.
Your Honor, this is John Lucas, but you'll see staying Zealand Jones for Collins Street. There's no objection to joint administration, of course.
And I apologize, Mr. Harvey. I don't mean to commandeer the agenda. This is really just a concern about the orderly administration of the case. So rather than my making the motion, why don't I pass the baton back to Mr. Harvey and give him a chance to be heard?
Sure, Your Honor. As Your Honor recognizes, we filed a joint administration motion. There's no dispute, and the evidence is in Mr. Ronke's declaration that these entities are all affiliates. They all share a common parent company, that being the Australian publicly traded parent. So they clearly meet the definition under the bankruptcy code of affiliate, and therefore satisfy the requirements of the bankruptcy rule 1015 for joint administration. As our motion makes clear, this is for procedural, not substantive purposes, so procedural purposes only, and we'd ask that relief be granted as customary and facilitated with an orderly administration of the cases.
Okay, thank you, Mr. Fox.
Good afternoon, Your Honor. May it please the court, Tim Fox on behalf of the United States Trustee. I just wanted to appear briefly, excuse me, and indicate that my office had no comment on the joint administration relief sought by the debtors today. I did, however, just want to alert Your Honor that I'm currently double booked and just adjourned a 341 meeting. I intend to resume that at 3:30 to the extent proceedings here are still ongoing. I would just ask to be excused in order to pick up that baton and carry on with those duties.
Certainly. Look, this is an emergency hearing, and it was scheduled on on short notice, and I appreciate that folks have other obligations, and that's entirely fine. So thank you for letting me know, but no concerns at all. Mr. Lucas.
Thank you, Your Honor. John Lucas, Chelsea Stings, Zealand Jones. No objection to the joint administration, of course, Your Honor.
Okay, so we'll get that order entered now. I will, Mr. Harvey, get out of your way and let you take us to wherever you think we should go next.
Thank you, Your Honor. We'd really like to start today with the cash collateral motion, given that it's contested, and the other motions that we're seeking depend on that relief being granted, particularly the wages motion. If the court does not grant use of cash collateral, we won't have an ability to make those wage payments, and we will have tough decisions to make. We would probably need a break to figure out where we go from there. And maybe we're even talking abandoning the mines to Collins, who seems to want the result of taking over what will effectively then be holes in the ground. But we're not there yet, Your Honor. Hopefully you'll grant our cash collateral motion today. So we do propose to take that up first and go straight into the evidence on that and then argument. Assuming Your Honor is okay with that, I would cede the podium over to my colleague Eric Schwartz, who would present the direct testimony by live examination of Chris Walker, the debtor's chief financial officer.
Okay, so I'm certainly fine with that. Let me just say before we launch into the evidence, based on my review of the papers, what I'm interested in understanding is what assets are unencumbered and what value do they have, which seems to me to be the nub of, unless I'm misunderstanding it, I don't want to start an argument now. I just sort of want, just to the extent it's helpful to the parties. As I understand it, there's no dispute that the cash, that is cash collateral, and that you're proposing a replacement lien, and the question is on what? And, I'm happy to hear whatever you want to provide, but to me, that's what I need to understand. So with that, let me, I say that not because I want to, take up everyone's time with argument at this point, but I just, so you have the target to shoot at, that after reading the papers was the questions I had coming away with it. So with that, let me allow you to pass the baton to Mr. Schwartz, and we'll hear the evidence.
Thank you, Your Honor.
Mr. Schwartz.
Good afternoon, Your Honor. May it please the court, Eric Schwartz, Morris Nichols, Arson Tunnel, on behalf of the debtors. Your Honor, I'd like to call Chris Walker to the stand.
Okay. Ms. Barksdale, can you administer the oath?
Yes. Raise your right hand, please. Do you affirm that you will tell the truth, the whole truth, and nothing but the truth to the best of your knowledge and ability?
I do.
Please state your full name and spell your last name for the record.
Christopher Shane Walker. Last name is spelled W-A-L-K-E-R.
Thank you.
Okay, Mr. Schwartz, you can proceed.
Thank you, Your Honor. Mr. Walker, what is your current position at the debtors?
I am the Chief Financial Officer for Allegiance's U.S. operations.
And what are your responsibilities?
I'm responsible for the finance and accounting functions at our two operating mines, the New Elk Mine in Colorado and the Black Warrior Mine in Alabama.
And how long have you been Chief Financial Officer?
I joined the company at the beginning of January of this year, so a little under 2 months.
And prior to that, what were your work experience as well as your educational background?
So I have a bachelor's and a master's in accounting from Clemson University. I have a master's in business administration with a focus in finance from Washington University in St. Louis. Specific to my coal experience, I spent 14 years with Peabody Energy. Peabody Energy is the largest private sector coal miner in the world in terms of volume and a significant participant in the seaborne metallurgical and thermal coal markets. At Peabody, I had a variety of roles in the finance, strategy, and marketing organizations, and most recently, I led the sales and trading, the international sales and trading function for Peabody based in Brisbane, Australia, but it did include oversight of the marketing functions of Peabody's mine in Alabama, which is actually very close to Allegiance's Black Warrior mine.
And do you have any experience in Chapter 11 restructuring?
I do. During my time at Peabody, in either March or April of 2016, Peabody entered a Chapter 11 process, emerging just under a year later. At the time, my role with Peabody was leading the sales support and contract management function.
And in your prior experience, do you have experience preparing budgets?
I do, and specific to my role at Peabody during the Chapter 11 process, me and my team were responsible for contributing to the expected revenue side of the picture, seeing that we oversaw all the sales agreements that Peabody had.
And are you a licensed CPA?
My CPA license is currently inactive. I did not continue my continuing education credits after I left public practice.
And can you generally talk about what are the collateral needs, the cash collateral needs for the company?
Yes, so we anticipate that over the next roughly 2 weeks, or better said, through the week ending Friday, the 3rd of March, to continue ordinary course business, to make ordinary course expenses. We need about $4.5 million, and we anticipate that the revenues received during that period will exceed that total.
So the budget's prepared to pay ordinary course expenses. That's the basis for the budget.
That is correct.
And has the company prepared a 2-week budget?
Yeah, they have. We keep colloquially calling it a 2-week budget. It's really the post-petition period of this week that we're currently in, as well as next week.
And were you involved in the preparation of that budget?
I was.
And Your Honor, I'd like to pull up the budget so everybody can see it, with Your Honor's permission.
Certainly, and that's at the end of the cash collateral order that is proposed. Yeah, okay.
Your Honor, I see at the podium Paige Topper, since she's the expert on this.
Certainly. Ms. Topper.
Good afternoon, Your Honor. I just need access to share my screen.
Okay,
I can pull it up.
and you're logged in separately as you?
Correct.
We can do that. And as ever, that's my taking credit for what everyone else is doing.
Thank you, Your Honor.
Likewise, Your Honor, taking credit for saying.
Okay, so Ms. Topper, you should now have screen sharing access, and Mr. Schwartz, you can continue taking credit for all of her work.
Thank you, Your Honor. Mr. Walker, if you could walk the court through this first page and explain on a line-by-line basis what is on this page.
Yes, absolutely. So this has the 2 weeks that I outlined before, with the 24th being the post-petition period through this Friday, and then the second week through the 3rd. I should point out that we do this in terms of week ending Friday because of expenditure and payable, or expenditure and revenue receipt. It kind of works on that schedule, but the mines do have operations that go through the weekends. So the first line is our receipts mechanism, and that is sales of our coal that we mine. You'll see that it's quite a big disparity between week 1 and week 2. There's two things driving that. One, this was prepared post-petition. We had significant receipts this week or before the petition. And two, our sales by their nature, and I'm sure we'll get into this, can be fairly chunky as we assemble contract volumes for customers. So that larger number in week 2 does have a number of sales in it, contributing to that roughly 6.6 million. The operating disbursements, starting with the payroll, the two operating companies have a 2-week payroll cycle in arrears that is offset by 1 week. So for the most part, the week 1 number is the New Elk payroll amount, and the week 2 number is the Black Warrior payroll amount. The other disbursements is a post-petition look we did vendor by vendor. What do we need to stabilize the business in light of the filing? Which vendors are critical based on what stock levels we have for various parts, what services we'll need. And we think that these are the payments for goods and services generally post-petition that we will need to keep the business running. This does have a few pre-petition balances being settled due to carriers having custody of our coal and needing to monetize that coal to create value versus the expenditure we feel we need. That drives the net cash flow from operations. We currently don't have anything on legal fees or other restructuring fees in this analysis. Those cash flows are applied to our cash balance at the time of petition, and you see the ending cash balances at the last line for the respective weekends.
Thank you. We could bring up the next page of the budget, please. So in respect to this page, Mr. Walker, if you could take the court through the categories, it's not necessary to go on a line-by-line basis, but explain to the court what this document is and how it ties into the first page of the budget, please.
Yeah, so the two tabs that we'll review sum into the consolidated sheet that we viewed first. This first tab speaks to the New Elk component of that. The receipts, the anticipated receipts for coal sales is the first section. The next section is employee-based expenditures. The payroll figure at the top there, and then related employee expenses such as independent contractors. New Elk in particularly leans fairly heavily on independent contractors that we have either a direct relationship with or use an employment agency as a means to help attract employees to a fairly remote operation where one of our larger challenges is attracting a skilled workforce. Related to that, you see employee accommodations. We provide employee accommodations in certain instances to ensure that we can get a skilled workforce in that area of Colorado. Goods and trains that I touched on a moment ago, that's related to a carrier, Burlington Northern Santa Fe, the rail carrier who's currently got a train en route from our operation to the Port of Mobile. And then finally, the trade section refers to that vendor-by-vendor analysis that I mentioned we went through of what we think we need to ensure the business continues operations over this week and a half, 2-week period.
And again, you prepared this document as Chief Financial Officer of the company.
I did, with close collaboration of the broader operations team, particularly on getting a feel for exactly where our stock levels were on certain parts and what vendors we would need during this initial period.
Thank you. If we could go to the next page of the budget, please. And again, if you, Mr. Walker, explain to the court this page, again, by category, that would be great.
Yeah, so the sections remain the same. The receipts of the coal sales that we anticipate over this period. You'll see the employee base, the payroll is offset by 1 week, as I described earlier. We do have a few paper checks that were written on the prior payroll that have been stopped as part of this petition. That's that 12,000 line. You'll notice here that we don't have amounts as material on the independent contractors or accommodations. There's a much more robust mining sector here in Alabama, and we don't have to go through quite the same steps to attract a qualified workforce that we do in Colorado. Goods in transit is the same concept as I described for New Elk, only in most cases, or in many cases, we move our coal via barges down the Black Warrior River. Parker Towing is the company we do that through, so they have barges in transit that we're trying to get delivered to customers and turn into cash. And the trade line, it's the same concept. Black Warrior is a surface mine, so certainly the nature of the goods and services differs from the underground mine at New Elk, but again, it's working with the operational teams and saying what vendors do we need to ensure operations continue over this period.
And again, you prepare this page of the budget as chief financial officer?
That is correct.
Okay. Your Honor, the debtors would like to move into evidence the budget with the 3 pages.
Is there any objection?
No, Your Honor.
Okay. The document will then be admitted into evidence.
Thank you, Your Honor. And did the company, Mr. Walker, prepare a longer-term budget?
We did. We prepared a similar budget that ran through the beginning of June, roughly a 15-week look.
And were you involved in the preparation of that budget?
Yes, I was.
Your Honor, again, I'd like to present that budget to the court and pull up on the screen.
Okay.
And Mr. Walker, what period does this budget cover?
This covers post-petition through the week ending June 2nd.
And were you, again, involved in the preparation of these numbers?
Yes, I was.
And can you explain to the court this budget? I assume it's similar to the other one, it's just for a longer period of time.
That's right. It's the same format, same concept, comparing what we anticipate for receipts for coal sales and the timing of those, applied to our anticipated payroll and ordinary course expenses to run the 2 mines.
Now, this 15-week budget does not include professional fees. Do you have any feel for what those professional fees might be during that time period?
It does not include them. I was advised that we can expect at this stage professional fees to be in the neighborhood of $1.5 million over this period.
So if you include those professional fees in this budget, at the end of this time period, how much cash is on hand?
So that would imply that we have a little over $4.2 million of an ending cash balance of the U.S. entities when you take into consideration $1.5 million of professional fees.
So this budget, like the 2-week budget, is showing that the cash flows are increasing over the period of the budget.
That's
So
right.
I apologize. Just wanted to make sure I'm following this. So looking at the document in front of me, it shows an ending cash balance of $4.6 million. Am I looking at that correctly?
Yes, if that question is for me, Your Honor, yes.
So when you said that it shows a final cash balance after accounting for fees of 4.1, did you mean 3.1?
Sorry, if I said 4.1, yes, I misspoke, Your Honor.
Got it, okay. And I also could have misheard. I just wanted to make sure we're all rowing together. Okay, I apologize. Mr. Schwartz, you should resume. Apologies to all.
Thank you, Your Honor, for having that correction made. So at the beginning of the budget in February 24, 2023, the beginning cash balance is $1,730,000. Is that correct?
That's correct.
And then as we just discussed, it goes up, if you include professional fees, to over $3 million.
That's right.
Does that indicate to you as the chief financial officer that the value of the company is increasing during that period as well as including the 2-week period for the use of cash collateral?
It does.
Objection to, Your Honor. Your Honor, good afternoon. It's Max Litvak with Mitchell C. Stangs, Zealand Jones on behalf of Collins Street, the secured note holder here. I wanted to lodge an objection to that question.
Okay, what's the basis for the objection?
That it assumes facts, not in evidence. He asked about, and I apologize, Your Honor, he asked about the value of the company based on the ending cash balance.
Fair enough, Mr. Schwartz. Do you either want to respond to the objection or rephrase the question?
The question I thought I asked you on was, as chief financial officer, did you indicate to him that this was an increase in the value of the company?
Right, and the objection is it assumes facts not in evidence, and it seems to me that it does because it assumes that the value of all the assets that aren't cash are consistent throughout the time, and there's not a basis for it. So I think that's the basis for the objection. So what's your response to that objection?
No, I can rephrase the question.
Okay.
Does the budget demonstrate that the value of the cash balance for the company will increase during the 15-week period?
Yes, it does.
And what does that mean to you as chief financial officer?
That these operations will generate positive cash flow during that period.
And the fact that they can generate positive cash flow, what does that mean to you with respect to the company itself?
It tells me that continued operations of these of the two mines is additive to the value.
Your Honor, I'd like to move into evidence of this budget.
Any objection?
No objection.
Okay, it'll be admitted.
And again, can you explain to the court the needs over the next 2 weeks?
Yes, so we need to utilize the cash of the U.S. operations to cover ordinary course expenses, to ensure operations continue, and to ensure that we monetize not only the coal that we currently have mined and is in the logistics chain, but also profitably monetize coal mined during that period.
Now, do you understand that part of the cash collateral here is the cash balance of the company?
Yes, I do.
And do you believe from the budgets and your experience, not only as chief financial officer of the debtors, but your prior experience, that the cash collateral will go up in value because the cash balance is going up in value?
Use of those funds, I believe, will generate positive cash flow, additional positive cash flow as demonstrated here.
And what will be the impact of the company if it doesn't get the use of cash collateral for 2 weeks?
So if we are not able to meet payroll or ordinary course expenses for goods and services, both operations will almost certainly shut down immediately. And we would need at a minimum some cash to monetize the coal currently in the supply chain to receive most of those revenues that we see detailed in that budget. Some of those are invoiced and completed transactions where just the cash receipt function is remaining, but the bulk of them still have movement required in the logistics chain. So without the use of any of those funds, most of those revenues cannot be monetized. The mines would immediately shut down in a very disorderly manner, and certainly any future revenues from yet to be mined coal would go away, and there would certainly be expenses, a care and maintenance circumstances at both mines, which would be aggravated by the fact that it would be a very disorderly and abrupt shutdown of the operations.
Thank you. Your Honor, may I have a moment, please?
You may.
Thank you. Thank you, Your Honor, for the time.
Certainly.
Mr. Walker, are you aware of the book value of the operating mines?
Sorry, can you repeat that question?
Are you aware of the book value of each of the operating mines?
No, I am not.
Excuse me, 1 second. Your Honor, no further questions at this time.
Okay. Is there any cross-examination? Mr. Litvak.
Yes, Your Honor. Again, Max Litvak for Collins Street. Mr. Walker, can you hear me okay?
I can, thank you.
Good afternoon. I'm one of the attorneys for Collins Street, the secured note holder here. Mr. Walker, nice to meet you via Zoom.
Nice to meet you.
Let me ask you, my first question is, I think I heard you testify that you became employed with the debtor just a couple of months ago. Is that correct?
That is correct.
When was your first day?
January 3rd.
And how is it that you came to become employed by the debtor? What is it that brought you to the debtor?
I mentioned my experience with Peabody Energy between my time with Peabody Energy and joining Allegiance. I was an independent consultant in the coal industry, primarily helping clients with the marketing side, and particularly a focus on the seaborne thermal and metallurgical markets. I believe that metallurgical coal is a scarce resource that has a long runway for being needed in the steelmaking process. We've seen exceptionally strong price movement over the last 2 years, reflecting what I believe is to be a fundamental undersupply. Allegiance has 2 metallurgical mines with access to the seaborne market. The seaborne market is the most liquid arena to transact metallurgical coal, where I think there will be strong pricing support. I think these are good assets. I was excited about the opportunity, and I knew there were challenges, but I saw a lot of upside with these assets and was excited to join the company.
Did you have any prior relationships with any of the representatives or officers or directors of Allegiance Coal prior to you joining?
I did not.
Were you surprised that the debtors needed to file for bankruptcy within a month or so after you joined as CFO?
Objection.
What's the basis for the objection?
Your Honor, I think it's kind of a vague question, it's a surprise. But I'm not sure why he's asking the question. Not sure what it has to do with the testimony that was previously presented to the court.
Mr. Litvak?
There was testimony presented about the background of this witness. I'm just trying to get some sense of what he knew coming into this engagement.
I'll overrule the objection on the theory that it's arguably relevant background, but obviously let's than try to focus on the specific matters at issue. So you can answer the question, Mr. Walker.
So I've seen a lot of boom and bust cycles in the coal industry. I've been through a restructuring as we talked about. I'm certainly not naive to the challenges that the extractive industry and certainly the coal industry can face. So I knew that was certainly a possibility. Would I have put my P50 prediction that would be Chapter 11 filing on this time frame? Absolutely not. That I would not have expected that.
And in coming into this role, did you do any analysis in terms of the historical financial performance of the debtors?
Yes, I did.
Did you look at the debtors' financial projections over prior periods?
I looked at everything that was publicly disclosed, and that I really looked at everything that was publicly disclosed, period. But yes, specific to your question.
Did the debtors also provide you with any financial information that was not publicly disclosed?
Not before I joined the company.
Have you had access to that level of information since you joined?
Yes, I have.
Are you aware, Mr. Walker, that Collins Street lent money to the debtors last year?
I am.
And is it correct to say that approximately $30 million in US dollars is now owed to Collins Street by the debtors?
And I'll object to the extent that he's asking, say, if it's owed or not. We just filed.
I'm sorry, Mr. Schwartz, what's the basis for the objection? I may just not have heard you clearly.
Sure. We just filed bankruptcy, Your Honor, and he's asking us to say that we owe a specific amount to them. And Your Honor, this case, we filed a petition, and now we're having a different than typical first day. So the debtor needs to go through its normal analysis, etc.
I think the question, to the extent it's looking for a generic overview of the state of the debtor's financial condition, that would normally, frankly, is set forth in the first day papers and is sort of typical to what would be addressed on a first day is fair. If it goes much further afield, I'll bring it back. But I think that question is asked, again, not to commit to the specific number, but to the extent it's asking broadly about generally the company's balance sheet and capital structure is fair.
Thank you, Your Honor.
So, Mr. Walker, with those caveats, you can answer with respect to your general understanding of the company's, capital structure.
Yes, I am aware of that.
And that debt is secured by substantially all of the debtor's assets, correct?
Again, the same objection, Your Honor. It really calls for a legal conclusion with respect to asking that everything is secured.
Well, that's partially legal and partially factual, and to the extent the witness has an understanding about the facts, it's clearly relevant. Maybe it's beyond the scope, but unless you're telling me you want him to be called again and have this take longer, it seems to me it's a fair question.
Yeah, Your Honor, I'm not trying to be difficult. I'm just trying to not have us as a debtor, not have him be bound to a legal conclusion or otherwise.
I'll allow the question on the understanding that it's simply the witness's understanding, and he's not here in a way that and only that. So, with that, to the extent the witness knows the answer, you should provide it.
Yes, that is my understanding.
And Mr. Walker, you're not aware of any unencumbered assets in the debtor's estates, unencumbered by the liens of Collins Street, correct?
Again, Your Honor, I'll just make the continuing objection.
Okay, and I'm going to overrule it on the same basis that to the extent you want to come in and correct it, I'll permit that, but I think it's clearly relevant.
No, I'm not aware.
You're not aware of any unencumbered assets, right?
Again, I have the same objection.
Your Honor, I don't think it's necessary to object every single time, every question.
All right.
The same basis as the prior objection.
All right.
It's ridiculous.
we'll have the witness answer this question, and then Mr. Lefek will take it from there. So you can answer that question.
No, I'm not aware.
Okay.
And in terms of the cash collateral use that the debtors are requesting now, that's cash collateral of Collins Street, to your understanding, correct?
Yes, that is my understanding.
Let me ask you about historical cash flows with respect to the debtors. You mentioned earlier that you're familiar with, you were provided with information about the debtors' historical financial performance after you joined the debtors, correct?
Yes, that is correct.
And have the debtors been operating at a loss over the last 6 months?
Yes, they have.
Every single month?
I don't know that off the top of my head.
Did the debtors lose money in January?
I don't know that off the top of my head. And just to be clear, when you say lose money, are we talking? Is the question related to cash flow? Is it related to an accounting profit and loss? We have not issued financial statements for January as a quarterly reporting period. So I don't know that that's an answerable question.
Well, let me just ask you in terms of, let's just look at the net cash flow of the debtors, okay? What was the debtor's cash balance when you joined the company?
I don't know that off the top of my head.
Okay. Your budget, your current budget shows 1.7 as the starting balance as of petition day, correct?
Yes, that's correct.
Okay. What happened with that starting cash balance over the prior month? Did it come up, come down? Describe that for me.
I think what you're trying to ask is, has the debtor generated positive or negative cash flow over an undefined period here? And the answer is that generally the period we would look at in the rearview mirror would be negative cash flow, which is not inconsistent with a junior miner developing mines as they mature and increase production levels and place their presence in the seaborne markets with customers.
Is it fair to say that the debtors thought or expected to be cash flow positive by fall 2022, but that didn't happen, right?
I don't know what you mean by the debtors thought.
Well, the debtors provided projections to Collins Street in the summer of 2022 that they would be cash flow positive by fall 2022, but that didn't happen, right?
Your Honor, I'm objecting. He's stating facts that are just not in evidence.
He's asked a question, and the answer will either be yes, no, or I don't know. So I'll overrule the objection.
I can't speak to what projections were given to Collins Street in June, or I apologize, I forgot the month you mentioned, but
I said summer.
Okay, thank you. Summer of 2022.
Okay. When was this budget prepared?
Can you clarify when you say this budget, which budget you're referring to?
The 15-week budget that Mr. Schwartz asked you about and was admitted into evidence.
This was a post-petition budget that was prepared, so really we've been scrambling on this since they've been long days. I think it was Tuesday night, if I've got my days straight here.
You've never presented, you, meaning you personally, Mr. Walker, or the debtors, never presented a budget to Collins Street that showed positive cash flow. Have they? Have you?
Your Honor, I only object to the standpoint that he says debtors, and he's asking his own personal knowledge. I'm okay with that.
I will allow the question to the extent it asks the witness about his own personal knowledge.
Yeah, my personal knowledge, no, we have not, but I certainly don't know the whole of the budgets or financial projections provided to Collins Street.
So how much, just to give the court a sense of it, how much have the debtors lost on a monthly basis on average over the last 6 months?
I don't have that number in front of me.
Can you estimate it on a monthly basis? Would it be 1 million? Would it be 5 million? Can you give us a ballpark?
I'd be happy to look into that, but I don't have that number in front of me. I don't want to give you a ballpark number without having some degree of confidence.
See, so you became the CFO 2 months ago, or less than a month and a half ago, right?
I started on the 3rd of January of this year.
Okay, and now for the first time, you've prepared a budget that shows that all of a sudden the debtors are going to be cash flow positive on a month-to-month basis over the next 3 months, right?
If you're asking if the budget that you referenced earlier, the 15-week budget, if you're asking whether that shows positive cash flow, the answer is yes, it does.
And notwithstanding the fact that that's completely inconsistent with the debtor's actual performance over the last few months, right?
Yeah, I object, Your Honor.
I'll overrule the
I'm
objection.
trying to ask a question on cross.
Yeah, it's cross-examination. It's a fair question on cross-examination. You can answer the question, Mr. Walker.
Could you repeat it, please?
Yeah, Mr. Walker, you proposed a budget that shows positive monthly cash flows, notwithstanding the fact that the debtors have never had positive monthly cash flows. Yes? Is that correct?
This budget is a forward view. This doesn't provide any commentary on what's in the rear view mirror. This is solely speaking to the post-petition period running through the beginning of June. So it wouldn't have any bearing on what that financial performance that you're referencing is in the past.
And I think you admitted earlier that this budget doesn't have any restructuring costs in it, correct?
That is correct.
And then you further testified that you were told that the restructuring costs would be estimated about $1.5 million over the 15 weeks of this budget, correct?
I was told that it would be legal fees of $1.5 million that relate to the U.S. entities where I'll admit I get tangled up when we get outside of my remit and get into the Australian entity. I certainly should have mentioned during my job responsibilities that I did describe that I'm over the U.S. operations, and I liaise with the corporate secretary based in Sydney who plays a role in the Australian side of things. But yes, that is correct. $1.5 million the anticipated legal fees associated with the U.S. operations over that period.
So it's just legal fees, it's not financial advisory fees.
I took that as legal fees, but again, that was not my estimate. I don't have a basis with which to make my own estimate there.
Well, who gave you that estimate?
My legal team.
Does it include committee fees, creditor committee fees?
Again, same answer, I don't know. It's outside the scope of my understanding of what it takes to walk through this process from a legal advising and restructuring. The concept part of that is, of course, that we are operating on a very abrupt timeline here and trying to get all these ducks in a row as quick as we can. So that's why I took the $1.5 million as a good estimate at this stage.
But it could just as easily be $3 million for all you know, right?
For all I know, if my legal team was advising me poorly, but I doubt that's the case. I assume that estimate was in good faith and is a good estimate.
Well, did you drill down on what goes into that $1.5 million? Do you have a breakdown of what that is?
No, I'll go back to the abrupt filing concept and the time spent putting together the budget and everything else that we've had to prepare to put together. So no, I don't have any at this stage detail on that $1.5 million.
Do the debtors intend to hire a financial advisor, like a Chapter 11 financial advisor?
That's being evaluated right now.
Do the debtors intend to hire an investment banker?
That's being evaluated right now. And of course, some of these decisions will be directed by what happens today at this hearing and coming proceedings.
And let me ask you, just mentioned that you do coordinate to some extent with the Australian parent, correct?
I liaise with the corporate secretary based in Sydney.
And has the corporate secretary now been displaced by an insolvency administrator in Australia?
I'm not sure the current status.
Have you spoken to anyone there since the insolvency proceeding in Australia was commenced?
When was that proceeding commenced?
A couple days ago. I would think it's concurrent with the filing by the debtors in the U.S.
If it was concurrent with the filing with the debtors in the U.S., no, I have not.
Does the Australian entity send money to the debtors, or has it sent money to the debtors in the past?
My understanding is it has in the past. It has not since I joined the company.
Has it ever been the case that the debtors, the U.S. debtors, send money to Australia?
It has not been the case since I joined the company. I'm not sure before that.
Is it the case, Mr. Walker, that the debtors can't rely on receiving any more money from the Australian parent, given that it is involved in its own insolvency proceedings now? Is that fair?
I object.
On what basis?
Well, he's asking him to conclude that because of the foreign proceeding file, that now no money can come into the U.S. entity.
If he has an understanding as CFO on which he can answer the question, he can, and if he doesn't know, he can say he doesn't know.
Thank you, Your Honor.
My understanding is at this stage, the current state of affairs is that no, we cannot.
And you're not assuming that in this budget, the 15-week budget that we've been looking at, you're not assuming any receipts from Australia either, correct?
That's correct. No, I am not.
Do you expect that the debtors will need debtor in possession financing during these cases?
This cash flow statement would suggest that if we are able to use the cash collateral that's currently on hand in the U.S. entities, we would not necessarily need debtor in possession financing over that period.
And are the debtors involved in an effort to obtain DIP financing at this point, or not?
Yes, they are.
How would you describe that effort? What are they doing?
Given the abrupt nature, I'd describe that as still early stage. We are evaluating sources of DIP financing.
How much are you looking to raise?
I don't know at this stage.
Why are the debtors looking for DIP financing if your own cash collateral budget shows that you don't need DIP financing?
I am not going to be able to answer that. I think there are legal ramifications that I don't appreciate about how we proceed through this process.
Could it also be that you don't believe your own projections?
I object, Your Honor.
Pretty basic question.
Yeah, this is cross-examination. It's a fair question.
Can you ask that question again and include the first part of it? Because I think it was a add-on to a previous comment.
Could it be that you're looking for DIP financing because you don't believe your own projections?
No, that's not correct.
So can we put the 15-week budget back up? Could I ask Mr. Schwartz to have someone put that back up on screen?
Yes, we're happy to do that.
Thank you. So Mr. Walker, do you see this exhibit?
Yes, I do.
Do you see in week 2 of this budget or next week, you're showing 6.6 million in receipts from coal sales? Do you see that?
I do, and I apologize for how close I'm probably to the camera because it is very small, but yes, I do see that number.
Is it possible that that money or some of it isn't received next week?
Yes, that is possible.
And how likely is that?
The question is, some of that, how likely is some of that not received next week? That has a decent.
Some or all. Some or all.
Definitely not all. That's not likely at all. Some is possible. Some could come in this week. We think we're a bit conservative on some, and certainly in this business, timing of shipments, timing of getting to transfer of title and collecting revenue is always has a risk or has the potential to move forward or backwards.
Is most of that money that you project receiving next week, 6.6 million, is that most of it coming from a single source?
Much of it, well, define single source is when you ask single source, are you talking about customer? Are you talking about
customer?
Yeah, so we do have a number of javelin sales, thermal coal sales that are in the process of either being delivered or being paid and having already been invoiced. I could certainly get to a total with the spreadsheet, but I believe that is more than half, yes.
And is Javelin an existing customer of the debtors, or is that a new customer?
We've sold coal to Javelin for a while, and new customer, I mean, they're existing customer clearly because we have contracts in place. So I guess if you want to delve further, I'd like to understand your explanation of existing customer versus new customer.
Well, have they paid the debtors before?
We have had receipts prior to position from Javelin, certainly.
Any payments from Javelin this month?
Yes, we have.
Okay. And with respect to the disbursements in this budget, Mr. Walker, I think you testified this is basically ordinary course operations, right?
Yes, that's right.
And that's about 200 employees, correct?
Yes, that's correct. 125, 130 at New Elk, 75-ish at Blackwater.
And you're looking in the aggregate at about $2 to $3 million in operating disbursements per week, is that right?
Yes, that's correct.
Are those basically fixed costs? They're not going to fluctuate too much up or down?
Well, they're certainly not fixed costs in the accounting sense of the word. They're, for the most part, variable costs based on operational levels.
And forgive me, by fixed costs, I really mean that they're basically preset. I mean, they're predictable. You know what they're going to be. They're not going to go up much beyond what's in the budget. Is that fair?
I'd hate to make a generalization. You know, the example, of course, that comes to mind is we consume fuel. Surface mines in particular consume an awful lot of fuel. And as everyone knows, going to the gas pump, that price can move up or down fairly significantly. So, yeah, I'm not sure I'd be comfortable making that general comment.
So in fact, these disbursements could be higher than projected, is what you're saying, right?
Everything on this forecast could certainly be higher or lower. That's the nature of the forecast. But yeah, specific to the disbursements, they could be higher or lower.
And the coal sales, those are subject to market fluctuations in terms of value, yes?
The majority of them are, as we go out a 15-week period. So we're certainly getting into sales that will be placed based on market pricing levels.
And isn't it the case, Mr. Walker, that there are some royalty obligations pre-petition that have been incurred and are unpaid as of the petition date by the debtors?
Yes, that is correct.
How much do those total?
I think you're trying to ask primarily about mineral royalties, which would be the largest share. And I should say, I suspect you're asking about mineral and surface royalties at the operations.
Yes.
Is that fair?
Yes.
Yeah. So we estimate that about $3.8 billion is the due balance on the royalties of the nature that I just described. We do have some small throughput royalties and other royalties that are not material relative to that number, but yeah, the 3.8 number is where we estimate that at.
And are you paying any of that $3.8 million under this budget on a post-petition basis?
It would be helpful, at least for me, if you would flip to either the New Elk or Black Warrior tabs to show what we're expecting to pay in the next 2-week period. But yes, the answer to your question is yes.
And that's okay. I think we can keep it at a high level for now. Are you assuming that, for purposes of your budget, that post-petition royalties, as they're being incurred, are being paid?
Yes, that is correct.
Okay. Have you done any analysis of how much it would cost the debtors if they were to switch to a care and maintenance budget as opposed to an ordinary course operation budget?
We're currently preparing that.
And have you reached any conclusions on how much that would cost, say, per month?
No, we have not.
Okay. Well, there was one question I had. If we could go to the NECC worksheet, Mr. Schwartz, if we could have someone move it to that detail just for a moment.
On the 15-week years in your active see.
Yes, please.
Okay.
And if you could just scroll down a little bit to the totals at the bottom. Yeah, I just wanted to ask you, Mr. Walker, it seems like the expenses are all aggregated after the second week of the budget in that line item 41. Do you see that?
I see line item 41, yes.
And is it the case that that is aggregating the expenses on a weekly basis?
Yes, it excludes payroll and payments to the rail provider, but yes.
And why are you aggregating them on a weekly basis as opposed to breaking them out on a line item basis?
So for the 2-week forecast, we went through a vendor by vendor analysis. What do we need to stabilize the business? Where are the stock levels of critical goods? What are the services we need over that immediate period? We think we can do that with a high degree of reliability. I've mentioned working with the broader operations team on that. The further you go out, it gets more difficult to do a vendor-by-vendor assessment, for example. When is a motor going to break down? How quickly will we go through a certain consumable? So therefore, we applied a analysis of what it has cost us to run the business, what new liabilities have been incurred to run the business, not necessarily in the world we were living in pre-petition, where we were managing a payables balance, but rather from a go-forward, what does it actually take to run these operations? In the case of New Elk, which is up here, we, of course, carved out the historical impact of the rail shipments because we're specifically identifying that and planning on paying that on a prepayment basis. And that's when we get to, in the case of New Elk, this $800,000 number. That has actually trended positively over that study period, but we wanted to take a longer time scale to ensure it was an accurate representation of the cost levels that we believe will be required to run the mines at and achieve the operations or the production levels that we have modeled here.
So Mr. Walker, just to sum up, and I'm nearing the end here, Your Honor. I apologize for the length of this, but is it fair to say that you believe that the debtors can operate on a break-even basis?
This cash flow consolidated across the U.S. entities before the legal expenses and the restructuring expenses that you challenged me on the detail of suggests positive cash flow over this period of about $3 million.
But even if the debtors are able to achieve these projections and subtracting out the restructuring costs and so forth, the reality is that the debtors' coal inventory is being depleted, correct?
To clarify, are you talking about the coal inventory that is currently mined and somewhere in the logistics chain, or are you talking about the overall resource base that is in place at the mines?
Well, it's all of it, isn't it, Mr. Walker? It's all being depleted one way or the other.
Yeah, the extractive industries, by their very definition, as you take a unit of a product out, that resource base has one less unit than it had before that.
And so in that way, the note holder's collateral position is being diminished, correct?
I object.
What's the basis for the objection?
Well, when he says diminished, I'm not sure what he's trying to accomplish here, because obviously there are proceeds from that item, but he doesn't.
So look, it's a question, and the witness can answer it. I don't understand what the basis for the objection is. I understand possible answers.
Yeah, I'm not sure, Your Honor, and what diminished means.
I'll overrule that. Mr. Walker, you can answer the question.
Yeah, so one methodology of valuing mineral reserves is the total in situ resource, and when you deplete that, of course, just by the mathematical value of that goes down, but in reality, the vast majority of the value of a mine that has had any development on it goes far beyond the resource base. And just for scale, in particular at our New Elk mine, there's a significant amount of coal at that property. And to talk about on any time scale we've discussed here, the coal extracted being a reduction to the value of that resource base is really de minimis.
Your Honor, that concludes the cross-examination.
Okay. Mr. Schwartz, is there any redirect?
Your Honor, may I have a moment, please?
Of course, you may.
Thank you.
And the budget can be removed from the screen. I'm done with that. Thank you.
Okay. Mr. Schwartz, you have another witness.
Yes, we do, Your Honor. And I'm going to cede the podium to Mr. Reck.
Okay, I'm sorry. Mr. Fox, do you like to be heard?
Your Honor, I just wanted to identify that I may be departing soon from the hearing, just in light of the 341 I mentioned previously. I know that you gave me your permission to be excused. I just wanted to put on the record that at this juncture, the U.S. trustee does not oppose the relief sought here today, but obviously the debtor has its burden with respect to establishing the non-consensual use of cash collateral. I unfortunately will not be here to evaluate whether or not that burden has been fully satisfied, but I will try to rejoin today's proceedings if they're still ongoing when my 341 is concluded.
Completely understood. Thank you, Mr. Fox.
Thank you, Your Honor.
Okay, so counsel, you can proceed.
Good afternoon. For the record, Andrew Remington, North Central Russian Final for the debtors. As Your Honor is aware, we submitted a first day declaration from the CEO of the debtors, Jonathan Romke. I'd like to put him on the stand for a short supplemental direct.
Okay, when you say supplemental, are you moving the declaration into evidence?
We'd like to do that, and then I'll ask him some questions to supplement his first day declaration.
Okay, well let's take the first step first. Is there any objection to the introduction into evidence of Mr. Romke's declaration, which is on the docket at DI 10, and of course that is all subject to any party's right to cross-examine? Mr. Litvak.
No objection, Your Honor, that's fine.
Any other party in interest seek to raise an objection? Seeing none, the declaration will be admitted, and Mr. Reming, you can continue. Actually, why don't I do this? So you're calling Mr. Romke to the stand?
Yes, Your Honor.
Okay. In that case, Ms. Barstow, if you could administer the oath.
Please raise your right hand. Do you affirm that you will tell the truth, the whole truth, and nothing but the truth to the best of your knowledge and ability?
Oh, I'm sorry, Mr. Romke, you're on mute.
Yes, I do.
Please state your full name and spell your last name for the record.
Jonathan Eric Humphreys Romke, R-O-M-C-K-E.
Thank you.
Okay, Mr. Reming, you can proceed.
Thank you, Your Honor. Mr. Romke, what is your current position at the bank?
Please ask again.
I'm sorry. Mr. Romke, what is your current position with the debtors?
I'm the Chief Executive Officer.
Thank you. And what generally are your responsibilities as Chief Executive Officer?
I'm responsible for the whole company, to run them, from an operational point of view, to oversee and make sure they've got the proper supervision, oversee all the activities required at a corporate level.
Thank you. And could you briefly describe your prior work experience and educational background?
I'm a mining engineer by training. I left high school and went into underground mines in Australia, south of Sydney. I got my qualifications as a university graduate through education, a Bachelor of Engineering in Mining from the University of Wollongong. I also obtained qualifications as a underground supervisor and also a mine manager in Australia. I worked extensively for large organisations, for BHP early in my career, for Oak Ridge Limited, and then for the Glencore and Xstrata Group in various activities up to General Mine Manager and then Chief Development Officer or General Manager Development with Xstrata, and then later on with Glencore. I worked in iron ore industry for about 5 years, but predominantly my experience is in the coal industry.
Thank you. And how long have you been with the debtors?
Since May last year.
Thank you. Did you submit a declaration in connection with these Chapter 11 cases, Mr. Romke?
Yes.
Do you have that in front of you, or can you pull that up?
Yes, I've got it in front of me.
That's great. I'd like to direct you to paragraphs 12 and 13 of that declaration. Just let me know when you're there.
Yes.
Okay. What are these paragraphs generally about?
Sorry, please ask that again.
What are these paragraphs generally about, you could say?
From 13 onwards, you're saying?
Just 12 and 13, we'll start there.
Okay. 12 and 13 about the Collins Street note, which is a debt instrument that was established for the group last year.
And then if you could look at paragraphs 14 and 15.
Yep.
And what are these two paragraphs generally about?
This is about promissory note and security obligations associated with the lending note.
And are these the company's funded debt obligations?
I believe so, yes.
Are you generally familiar with the terms of the collateral package of the Collins note and the Klein note?
Yes.
Do you have an understanding of whether the lender has a lien on the proceeds of debtors' mineral leases?
I believe they do have a lien against mineral leases, except there was two leases that required permission from the holders, and they were the Warrior Met Coal leases and the State of Colorado lease with the Department of Wildlife. And those liens were not granted by the holders of the lease, is my understanding.
Okay. So just to confirm, it's your understanding that lenders do not have a lien on those two leases? Correct?
Correct. I'm just a little uncertain on the definition of a lien in that circumstances, but the agreement of the lessees was not granted, and we tried a number of times to protect those.
Thank you. In your role as CEO, have you become familiar with the debtors' books and records?
With the debtors'
Books and records?
Yes, to a certain extent, if you're talking about the accounting system itself that's used. No, I'm not an expert in that. Certainly at the corporate level of reporting, I'm very familiar with that.
And do those books and records reflect the value of the debtors' assets?
Yes.
Do the debtors own any operating mines?
Any operating what?
Mines, operating mines.
I'm not familiar with the term operating mines.
It's the operating mines, M-I-N.
Yes.
It's
my accent. Sorry about my accent, Your Honour. Yes, we own two operating mines, the Black Warrior mine and the New York mine.
Thank you. And are you aware of the value of the debtors' two operating mines you just mentioned?
It depends how you find value. We have a book value that is in our statutory accounts and reported annually in our annual report, and we maintain the asset register on a monthly basis to recognise changes in book value.
I have no further questions this time, Your Honor.
Okay, cross-examination, Mr. Litvak.
I'm sorry, Your Honor. One last question. You mentioned that you are aware of the value of the mines. What is that value?
The asset value against our asset register for the mines is 16 million for the Black Warrior mine and 43.6 in round terms for the New York coal mine.
Thank you. Now I have no further questions, Your Honor.
Okay, Mr. Litvak.
Mr. Romkey, Max Litvak on behalf of Collins Street, the secured note holder. Can you hear me? Okay?
Yes, I can.
Okay, great. Thank you, sir. Have debtors conducted an appraisal, a third-party appraisal of their mines?
We conducted some time ago, for my time with the organisation, a asset valuation, which is relative to the asset values I just quoted in the last question. That was done in 2019, I believe, and then Collins Street had us do another valuation, but did not share that information with us, and that was last year.
But from the debtor's perspective, it sounds like you're testifying that the debtors have not obtained a third-party valuation of their assets since you became CEO in May 2022. Is that fair?
That's correct. Apart from maintaining the asset register, which we have done.
I'm sorry, say that again?
We do maintain an update to the asset register, so as assets are acquired, the valuation of those assets is changed to reflect, or the asset register itself reflects the acquisition of new equipment, which was not included in the prior valuation.
So that's how you get to a book value for the assets, is that right?
Yes, that's correct. It changes as we acquire more assets to support the operations.
Okay. Are you also, or were you also on the board of the Australian parent, Allegiance Coal Limited?
Yes.
Is it your understanding now that you no longer have that role because you've been displaced by the insolvency administrator there?
I believe the system in Australia sort of stands the directors aside during the voluntary administration process in Australia. So I believe I remain as a director of that company. However, the voluntary administrator is appointed to manage all the affairs of the company during that process.
And the administrator, therefore, has control of 100% of the equity interests in the U.S. debtors. Is that correct?
Yes.
Let me ask you, you testified that there were two leases, the Warrior Met and State of Colorado leases, that consent was requested from those lessors but not obtained, correct? Consent for a mortgage by Collins Street, correct?
That's my understanding, yes.
You haven't come to any assessment of value about what those leases represent. Is that fair?
Could you ask the question another way?
Have you reached any conclusions about the value of those leases?
There was a previous definitive feasibility study undertaken for New Elk before I joined the company, and that was the basis of Allegiance Coal's acquisition of the asset in the first place. And I don't know what the valuation was. I can't tell you at the top of my head, but that was certainly quoted in the ASX releases at the time, two years ago. They were significant. I've undertaken to update our view of the life of mine plan as part of our effort to support refinancing in America so that we could pay down the Collins Street debt, and we're partway through that process.
So let me ask you a similar question that I asked Mr. Walker, which is that the debtors have been operating at a loss. This is the U.S. debtors over the last 6 months. Is that fair?
Yes, that's fair. If you look at the information available in the public arena, that is certainly published in the ASX and shows a loss.
And do you know how much on a monthly basis the debtors have lost?
Not at the top of my head on a monthly basis, no.
Can you give the court ballpark? You know, are we talking about $1 million US, $5 million US?
So it's of that order. It goes up and down, Mr. Litvack, based on wholesales primarily. Generally, our costs are relatively flat, but our coal sales are lumpy because it takes 2 months to assemble a Panamax cargo of coal for sale at the Port of Mobile, and then the proceeds of that sale come in a lumpy fashion sometimes. So it goes up and down on a cash basis regularly.
Do you recall that you provided certain projections to Collins Street in the middle part of 2022 for the debtors business? Do you recall that?
Yes, I do.
And is it fair to say that those projections showed that you anticipated that there would be positive cash flows by fall 2022?
Fall in Australia is different to fall in America, so let's use some months.
I apologize.
we did anticipate when those projections came that we would be able to turn around, particularly the production levels at the New Elk mine, such that we would become cash positive in the last quarter of last year, and that would have been in those projections that we shared with Collins Street at the time. And that was the reason I was brought into the company, was to bring a much stronger operational bent to the organisation and to be successful in those turnarounds. In the 6 months to the end of December, it's fair to say we had not effected the turnaround that we had planned, and that was still a work in progress and remains a work in progress today. And we've undertaken significant changes of senior management at the new mine, at New York mine, to effect that turnaround in the first and second quarter of this year.
So I think what I'm hearing you say, though, Mr. Ronke, is that at the end of the day, the debtors failed to meet their projections for the last quarter of 2022, correct?
They certainly failed to meet the projection shared with Collins Street, that's correct.
Okay. And did you have a hand in preparing the 15-week bankruptcy budget that we've been reviewing?
From a supervisory point of view, yes. I wasn't down in the weeds going through every vendor like my CFO was with the team, but certainly reviewed the outcome.
Did you tell the CFO that you wanted a post-bankruptcy budget that reflected positive cash flows?
No.
You didn't direct them to do that for you?
No.
Were you surprised to receive a budget that shows positive cash flow on a month-to-month basis?
We're going through a turnaround right now and changing our mode of operation at the mines such that we're going to be producing coking coal in the future. For the last 6 months, we have been producing thermal coal, and we believed we had a very viable option to fix that price of that thermal coal at $220 a tonne for all of this year. Unfortunately, a company that we dealt with did not live up to their expectations in the side of the deal, and so our cash receipts in the second half of this year fell with the falling market for thermal coal into Europe. And that market fell due to a very warm winter in Europe and significant gas supplies being imported to Germany to offset the Russian gas supplies, and very windy conditions, which meant that the electricity generation in Europe was significantly assisted by those windy conditions on the renewable systems. So the coal burn was not as affected, and hence the stocks built up in the port of Antwerp and Rotterdam, and that pushed the price of thermal coal that was $340 a tonne about halfway through last year, down to today's value for about $130 a tonne. So we decided to pivot our production back to coking coal, re-enter the coking coal market, where the prices have certainly escalated in the last 3 or 4 months, and indices are $350 to $385 a tonne. So we're in the process of transitioning to that new market, and that contributes to the revenue side of the cash flow projections.
And so when did the debtors make the determination that they were going to shift their strategy from thermal coal to metallurgical coal?
Over the last 2 months, we've definitely done that, and last month we've got reports that says we've made that decision. We've been producing coking coal at the Black Warrior mine at the reduced ash levels. for about the last 2 weeks, 3 weeks. So that transition's in effect. The last train, the train that is currently on the tracks on the way to Mobile, was our last planned thermal coal shipment, which has been sold to Javelin Commodities, and then the next train is meant to be to a coking coal standard.
So doesn't it seem risky, Mr. Ronke, to have the debtors, which have been losing money every single month that you've been involved as CEO, so now on a post-bankruptcy basis switch to making money through a new coal marketing strategy? Doesn't that seem risky to you?
Absolutely.
Or optimistic, I should say.
Absolutely not. It's, would you rather sell coal at $130 a tonne, or would you rather sell it at $208 a tonne? The strategy is very sound from a cash management point of view. We're not producing anything we haven't produced before. In the first half of last year, we produced coking coal from both mines. So we know we've got the capacity to do that. And it's not a decision that was made post-bankruptcy. It was a decision that was made month and a half ago.
Well, I guess, Mr. Ronke, you asked the question, what are you supposed to do? Another option that you could do is not sell any coal at all, correct? And go to a care and maintenance status. Is that right?
I don't think that's a viable option and maximises the value of the assets. So, that's why we don't have a budget at hand to do that. It's never something that the company has contemplated as a meaningful solution to becoming cash positive. Once you do that, there's no opportunity to become cash positive.
Well, Mr. Walker testified that he's actually working on a care and maintenance budget. Did you hear that?
That's been the request of Collins Street for us to do that, and if we can't achieve positive motions today, we'll be first forced into activities to do that, because we won't have the money to operate these mines as a going concern.
One other thing he testified to was about debtor in possession financing, and that the debtors are also looking for debtor in possession financing. Did you hear that?
Yes.
Are you involved in that effort?
Yes.
What is your involvement?
I've been talking to 4 organisations that are potential debtor in finance, offering debtor in finance funding. They're very keen with the opportunity, and so yes, very, very involved.
How much money are you looking to raise?
We haven't determined what the appropriate amount yet is, Mr. Liptak.
But you don't have any.
One company's offered 5 to 10. They came up with that figure. So I'm not sure the basis of why they thought it was 5 to 10, but I've been telling all of them we will work on what the needs and sources are, and part of that is the outcome of this, the motions today and future motions associated with the bankruptcy system in America.
But you're looking for that money, Mr. Ronke, because you're not sure that you're going to be able to meet these projections, right?
I'm looking for the money because we need a backstop. The cash flow, it's not, how would you say, it's not huge. So it's more like a continuing operation that is not super successful yet, and we're continuing with the turnaround plans that I mentioned before, and the coking coal prices that we're seeking in the market right now. So I think it's wise that we have the facility such as DOP financing that we can draw on if needed be.
But you don't have any commitment right now as you're testifying here today for DIP financing, correct?
I don't have written commitment. We've got very keen indications from 4 parties that they want to participate.
You don't have a sale lined up for the debtor's assets either, do you?
To sell the assets?
Correct.
No.
No. Did the debtors engage in any pre-petition marketing efforts with respect to their assets?
Pre-petitioning marketing.
Pre-bankruptcy, Did the debtors try to sell their assets?
We're in the process of discussions regarding the Telpa assets in British Columbia, and we've got 3 or 4 parties who have either signed an NDA or got access to our data room to assess those assets. We haven't started a formal process for the other assets, but under a bankruptcy system such as this, that's something we will have to do.
But the Telco assets, those are non-debtors, right? They're not involved in this bankruptcy case.
No, but they are owned by the Australian parent company.
Okay, fair enough. And the debtors never retained investment bankers pre-bankruptcy, correct?
No, I've been talking to investment bankers for a couple of weeks now, particularly at the insistence of Collins Street, so that we would be ready to go through that process if required. And I've got 2 firm proposals and offer letters from 2 organisations, or 3, I think one's come in today.
So you want to retain investment bankers now?
Yes.
And what would they be tasked to do?
As you described, look for sales options in the Chapter 11 protection process that we're going through.
You don't have any idea what the Chapter 11 plan here would look like, correct?
This is an emergency hearing because it's been dumped on us without a lot of preparation time, so I'm not sure what the plan will look like, and I certainly need the assistance of investment bankers that have been through that process to develop such a plan.
Okay. Your Honor, can I take a minute? I've been getting some emails from my client. I just want an opportunity to peruse those. Can I do that?
Yes, certainly, you may.
Thank you, Your Honor. Just a few follow-up questions. Mr. Romke, you probably heard Mr. Walker testify that there is about $3.8 million of unpaid pre-bankruptcy royalty obligations. Did you hear that?
Yes.
Is that consistent with your understanding?
That sounds approximately right. I'm not 100% sure, but yes, that sounds correct.
Doesn't that suggest that the debtors are, they were experiencing a lot of financial distress prior to the receipt of a default letter from Collins Street, correct?
We were working on
Production outside the scope of testimony.
So, Mr. Remy, you'd have Mr. Litvak recall the witness during his case in order to get an answer to that question?
If you could rephrase the question, in a way this is acceptable.
I'm going to overrule the objection. I'm going to permit him to go outside the scope so that he's only, Mr. Litvak, you understand that you're only getting Mr. Rumke now and not during your case?
Oh, Your Honor, I do not intend to recall him.
Okay, so on that understanding, I'll let you exceed the scope of the direct, and you can, so the objection will be overruled.
Could you restate the question, please, Mr. Litvak?
Yes, Mr. Romke, doesn't the fact that the royalty obligations have accrued to the extent that they did as of the petition date indicate that the debtors were experiencing severe financial distress before even receiving a default letter from Collins Street?
The royalties outstanding are one of a number of payables that we have outstanding. So, yes, we did not pay some of those royalties on time, and they have accumulated. We had an active dispute with Warrior Met Coal about the method of calculation of the royalties, and we're in discussion with that since last August, and it remains unresolved. So we were paying the minimum royalty amount according to the contract rather than the tonnage amount, and that has accumulated, which is, you know, and there's statements in what's before the court about the circumstances associated with Warrior Met.
And the other unsecured debts, aside from the royalty claims, have also accumulated, correct?
Well, some of them did, some of them we kept on top of, and some of them we had discussions with and understandings. We would catch up those payments as we became cash positive. We were making payments along the way to many of them.
And as of the bankruptcy date, those unsecured obligations totaled approximately $15 million, is that right?
Correct.
Okay. Your Honor, at this point, that concludes the cross. Thank you very much.
Okay, Mr. Remming, any redirect?
Your Honor, if I could have just a minute with my colleagues.
Certainly.
Thank you. Thank you, Your Honor, for the time. Just a few questions on redirect, if I may.
Certainly. You can proceed, Mr. Remming.
Mr. Rumke, we touched earlier on the two leases that the colonist does not have a lien in. Are those leases necessary to operate the mine?
Yes, sir.
Can you elaborate on that?
Sure. The lease in Colorado is one very large lease that covers all the area of the land and a surface portion as well as the coal seam, the underground portion, and that's administered by the state of Colorado. The other lease is a lease with Warrior Met Coal. It currently covers about 70 or 80% of the current working area of the Black Warrior mine, but there's probably 5 or 6 leases in total of the Black Warrior mine. And so it's a much more complicated mining lease system. Some of those leases are mineral-only leases and do not include the surface. Some are surface and mineral rights. This is over the whole area. And that's an area we plan to mine over the next 6, 7, 8, 9 years. So.
Thank you. And in your questioning from Mr. Litvak, you mentioned the Talqua entity mine in Canada. Do you remember those questions?
If I could elaborate on that, the Talqua Coal Company is a company registered in Canada, based in Vancouver, and it holds the leases associated with 3 coal deposits near Talqua. And the significant project that is nearly through an approval process is called the Tennis Project. And it's the most prospective project for initial development. I expect to have the approvals through there in 6 to 12 months from British Columbia. And that project that coal company is owned 100% by the Australian entity, Legion's Coal Limited.
Thank you. And as CEO of the debtors, do you have familiarity with the books and records of the entity that owns the Talqua mine?
The books and records?
Yes.
I'm not as familiar with that one.
Okay.
You want to know the book value? I do happen to know the book value of that project. That's $26 million Australian, and that's because we took a write down at the end of last year, and we had to make a board decision on whether that was the right figure.
Okay, thank you. And just a couple more questions. Yeah, you were asked about the Australian entity and the situation there. The Australian entity hold any cash?
Yeah, the Australian entity had just under $4 million cash in Australian dollars in their bank accounts.
Just 1 second, Your Honor. Nothing further, Your Honor.
Okay. Mr. Levesque, any recross based on that redirect?
No, Your Honor, thank you.
Okay. Mr. Remming, anything further evidentiary from the debtor?
Just 1 moment, Your Honor.
Certainly.
Nothing further from either of our witnesses, Your Honor.
Okay, Mr. Remke, thank you for your testimony. You can step off of the virtual witness stand. Okay, and so you've completed your evidentiary case.
That's correct.
Okay, Mr. Litvak, do you have evidence that you'd like to present?
No, Your Honor, we'll stand on the cross.
Okay, so I take it we now turn to hear argument. Is that where we are?
Yes, Your Honor.
Yes, Your Honor.
Okay. So, Mr. Remming, on the debtor side, I'm happy to hear from whoever is going to present the argument.
Thank you, Your Honor. I want to see the photo with my colleague, Matt Harvey.
Okay, Mr. Harvey.
Good afternoon again, Your Honor, and may it please the court for the record, Matthew Harvey from Morris Nichols Archton Tunnel on behalf of the debtors and debtors in possession. I think it's first, Your Honor, helpful to start with the context and the limited relief we're seeking today. We showed you and presented through evidence, I think, a lot of which was questioned but not really controverted by any competent evidence of a 2-week budget, which is the minimal relief we're seeking here. Essentially, for lack of a better term, to keep the lights on, to get the company to next week so we can engage in further discussions with its stakeholders and find a path forward in this case. And we presented the 15-week budget because an obvious question, I think, of Collins and a fair question of Collins in the court is this a bridge to nowhere, and where does it get to? Is it that we are going to build cash, as is evident in those 2-week budget, only to lose cash going in the future? So that's why we thought it was, even though it's not strictly the basis for a 3-week operating budget today, we presented that 2-week budget. So again, it's very limited relief, Your Honor. It's meant to focus on making payroll, continuing operations, which the testimony today made clear are value accretive operations for everybody involved. And there was some suggestion, and I'll get into what the evidence said in a minute, Your Honor, that, well, of course, you're depleting the underlying, it's a finite.
Yeah, no, and look, in the scheme of things that moved, I heard the point. I also heard the witness's answer that in the scheme of things, the depletion is de minimis, and that has a common sense to me. So I'm less moved by that. I am interested in hearing what the basis is, or what the evidence tells me the basis is, for in a world in which the company has been consistently running cash flow negative, for believing that the moment of the filing happened to be the point of the turn. That was the point where the hockey stick began pointing the other direction. I want to understand what in the record would support the reasonableness of that conclusion.
I'm going to get to that very briefly.
Okay.
decline to a slight increase here with a net build of cash flow with a de minimis or negligible impact on underlying collateral. But I want to focus on the legal standards and the burdens of proof today, first of all.
Okay.
First of all, we're talking about adequate protection under Section 363. We're talking about use of cash collateral, not use of other collateral, because there is no 363E motion for adequate protection of other collateral. So we're talking about a diminution, if any, in the in Collins Street's interest in cash collateral. And then we first have to look at what is that interest in cash collateral. And Section 363P of the Bankruptcy Code puts the burden on Collins Street to establish the validity, extent, priority of their interest in collateral. And that's relevant for two purposes today, Your Honor. Number one, they presented no direct evidence, any of their loan documents, any of their security documents, any of their alleged deposit account control agreements, establishing the validity, extent, or priority of any of their interest in collateral. They attempted to get a little of that in through our witnesses. Mr. Evans was probably not the best witness. I'm sorry, Mr. Walker was probably not the best witness on that piece. Candidly, testified that he wasn't sure about that. Mr. Romkey testified at a minimum, at least, on the mine that there were no liens granted on the two most valuable mines that are necessary in order to extract coal, 70 to 80% of the debtor's coal in the Alabama mine and in the Colorado mine.
So Mr. Harvey, can I slow you down here a minute? I want to make sure I'm understanding what we're fighting about and what we're not. So I understand your point about there being what is in effect a foot fault. But I've got to say I'm probably not likely to be with you there. It seemed to me, based on the totality of the evidence in front of me, even if I don't have the loan documents, I think the testimony suggests, and frankly the first day declaration, that what we've got is a blanket lien. Hold aside the two mines at issue. But with respect, I'm starting with use of cash, right, where you did. Right? And I don't think, based on the record, that I've got a dispute about whether the cash you intend to use is their cash. I understand I don't have the documents, but I'll just tell you, and I'll look at the record and all of that, but I think based on the first day declaration and the testimony, it seems to me that the preponderance of the evidence in front of me, even if it isn't definitive because I don't have the documents, still suggests that we're talking about using their cash. And so to me, there are two things that I've heard that I need to understand. One, you say, Judge, don't worry about it because it looks like their cash will accumulate rather than decrease, so don't worry so much. And second, you're saying we'll give them a replacement lien on an asset, these two mines on which they don't have a lien. So even if I'm wrong about the cash building up rather than depleting, they're still adequately protected. Let me pause there. Am I seeing the issues correctly?
There's a little more nuance than that, Your Honor, but I think that's broadly speaking exactly right.
All right, well, to the extent the nuance is important, tell me what it is. Please don't tell me I'm right if I'm not. I'd rather be right than have you worry about my feelings.
Oh, no, certainly. Well, and I'm not going to belabor, Your Honor, but on the 363P point, I do think that we as bankruptcy lawyers often lie burdens of proof. We often lie evidentiary burdens. But the case law is very clear on this. They have both the burden of proof and the burden of persuasion. The 363P2, I believe it is, that they have the burden on any hearing under 363, including 363A and C, to establish it. And this is not evidence, Your Honor, but we've been asking them days to produce their alleged security documents and loan documents to us and produce their witnesses if they needed them. And they declined to do both those. I should say they answered and said they would have no witnesses. But this has not been without notice to them. We told them we were going to need the file as a result of their declaration of default. We asked them for their documents. They elected to show up today and attempt to get their evidence into the debtor with no documentary evidence to establish it. So I don't want to waive that argument.
No, I understand, and I'm not asking you to waive anything, and I understand, and I'm a rather by the book kind of person, and clearly having the documents would be helpful. But the question is, overall, should I conclude that from the record in front of me, of evidence that's in front of me, that there's a lien, and what I've got is a declaration. And it doesn't matter to meet the burden, it doesn't matter who submitted the evidence, right? And there's a declaration that's been admitted by Mr. Remke in paragraph 12, talks about the Collins note, and it says, in words simple enough that even I can understand them, that that they're subject to first priority liens on substantially all of the assets.
And then in paragraph 3, right there on that same page, Your Honor, we said that this is not to be construed as an admission to the validity, amount, or priority of any lien or claim against the debtors. And in our cash collateral motion, we made very clear in a broad reservation of rights that we weren't disputing it because we expected the gentleman, the Pachulski firm who represent Collins, are very able attorneys, are aware of their burdens under the bankruptcy code. And quite frankly, we were a little shocked when they told us they had no witnesses and no documents, particularly because we've been asking them for days. Now, Your Honor, I don't want to dwell on this anymore.
Yeah, and you're making a fair point. I understand what you're saying. It's a fair point, and I expect to have questions for the other side about what you're asking. So I get it. But why don't we keep going? So okay, so you have an argument that they haven't met their burden under 362P of establishing the validity, the existence of their liens.
It's more than that, too, Your Honor. Validity, extent, it's validity, priority, and extent. What is the extent of their lien? Because it also goes into, if you take the view, and there's some judges, Judge Sanchi took a different view. Judge Sanchi's view was that you have cash collateral in the account as of the petition date, and at the end of the relevant period, if the cash that's in the bank accounts exceeds that, there's then no diminution in cash collateral. Others take the view that it's also things that convert into cash collateral. Regardless of those two views, it's important to understand, have they established a lien? If you take the view that it's other assets that are being brought into the estate, effectively proceeds collateral, it could be 363A, C, and 552B collectively, and these are identifiable proceeds collateral of their other collateral, and the argument then is that it is cash collateral. They need to make the factual predicate that they have a lien on those minerals. We need proof today, uncontroverted through Mr. Ronke's testimony, they do not have a lien on the leases in Alabama and Colorado through which that coal is extracted.
So can you help me with this? So your point about them not having a lien on the leases is that the proceeds of what comes in isn't their collateral. It's not. Are you making A, the point that the proceeds of that is not their collateral? B, that's available as a replacement lien, or both?
It can be either, Your Honor. I mean, you could take the view, and I think this is supported by the factual record we have today. There's $1.7 million in the till as of the bankruptcy filing.
Mm-hmm.
There will be over $4 million in the till at the end of next week. So if you take the view that it's cash in the till, beginning of the period, it's cash in the till at the end of the period, there's clearly no diminution in cash collateral. They're adequately protected because they haven't moved under 363E for protection of any collateral, and the only thing they're automatically entitled to is cash collateral. So assume they've met 363P, that they have a lien in cash collateral as of the petition date, and then they would next have to show under 363P they have a lien in the underlying assets that are being converted into proceeds which proceeds represent cash collateral. And if they have that, then arguably, again, some judges disagree, arguably they're entitled to adequate protection of that. My point today is they have not established that they have a lien in anything that's being converted into cash collateral. Even if you could say, for argument's sake, they have a lien in the 1.7 in the bank account as of the petition date, everything that's coming in from and after the petition date, there's absolutely no evidence today that they have a lien in that, because the only evidence that was uncontroverted by Mr. Litvak is that the two key properties, 70-80% of the production out in Alabama, which I understand is the predominant production at this point, and potentially more valuable production, they don't have a lien in. And in Colorado, they don't have a lien in. And so you have minerals that are being extracted, and they don't have a lien in the underlying assets. Therefore, they don't have a lien in those proceeds. Outside of bankruptcy, no 552A of the bankruptcy code, they have an after acquired property clause. Very easy. 552A cuts that off. They now have to rely on 552B, subject to the equities of the case exception. And I think they're proceeding on a fundamentally false premise today, or unproven premise, that they are entitled to the lien on that cash. They had the opportunity to make that record. We asked them if they wanted to make that record. They had the opportunity to present evidence. They didn't. And then the only uncontroversial evidence is they don't have a lien in those mineral leases. So they can't have a proceeds lien under 552B, which means they can't have a cash collateral lien under 263A that is entitled to adequate protection. But I don't want to belabor that point anymore, Your Honor, because I think you understand where I'm going about. Happy to answer any questions. I'll start next with, assuming they have a lien in all of that, assume they had shown up and proven the existence of the lien on cash collateral to begin with, the existence on the underlying collateral to have a proceeds lien and therefore a 363A proceeds cash collateral lien, there still is no evidence that any of that is diminishing in value or a threat of diminishing in value. So I'm not getting adequate protection yet. I'm talking about, is there anything that's even entitled to adequate protection?
So can I pause you there? So I hear your argument, and it's interesting that to the extent proceeds come in, whether those proceeds are their collateral or not is a disputable question. If the proceeds that come in are their collateral, then we've got the question of, okay, so we've got the cash balance. You project the cash balance will increase, right? Imagine, and that's based on testimony that is, has whatever basis it has. I'm not doubting the sincerity of any of the testimony, but these are projections about the future, so therefore necessarily uncertain. And we also know that in the past, the cash balance has generally decreased. If the cash value were to decrease, and even if the proceeds that came in and replaced it were not their collateral, wouldn't you still have a problem?
Add to the question we're here on today, 363A, C, and P, as to whether we're granting them. A solution there would be grant them a replacement lien to the extent of the diminution in their cash collateral by granting them a replacement lien on cash that is not their collateral, because that's an available source of unencumbered collateral as a result of 552A of the bankruptcy code, cutting off an after acquired property clause.
So help me with this. Let's imagine, I'm just trying to make sure I've got my head around this correctly. So don't infer anything about what I think the facts are, but I just want to make sure I've got these principles correct. The principles are at some levels very fundamental, but as you know, actually having a contested cash collateral hearing is rather unusual. So if I thought what the records showed was that they do have a lien on the cash today, but they haven't met their burden on the proceeds that will come in, basically the sales, the cash that will come in from the sales of coal over the go forward period. But I thought the cash balance over the 2 weeks was likely, rather than to increase, but instead to decrease. So right now they've got a lien on $1.7 million of cash, right? And if at the end of the 2 week period that you're asking for approval to use their cash, I thought there was going to be $1.6 million of cash. And so let's assume for this purpose that cash isn't inherently their collateral, because of the issue you demonstrated. It's proceeds. Meaning it's going to go from 1.7 to 1.6 because you're going to spend, right, all of the 1.7 and $1.6 million of new money will come in. Okay, obviously I'm cartooning it, but, let's say you're right and the 1.6 that comes in and is sitting there at the end of the 2-week period is money on which they don't otherwise have a lien. We could give them a replacement lien on that, but why does that adequately protect them from the loss of the incremental $100,000? Do you understand my question? Does the question make any sense?
Yeah, perfectly. And the factually and intellectually honest answer they would need, if we were actually certain of those facts, because then we're talking about adequate protection, not complete protection, we would be giving them an additional $100,000 of unencumbered assets in order to protect them.
And what does the record tell me? You're saying is the additional unencumbered assets would be receivables that would be in the pipeline as of the end of the budget period, essentially?
The additional unencumbered assets would be a lien only to the extent of diminution in value. I'm not talking about cross.
I understand.
Or a roll up. We're talking about if they lost that $100,000. The testimony from Mr. Ron today, and I believe Mr. Walker as well, that you have these 2 leases in particular, a lease in Alabama through Warrior Met Coal, which is another coal company in the area. 70 to 80% of the production down there comes from that lease. The lender does not have a lien on that today, on the lease, and we believe, or on its proceeds. And so if they got a lien on those proceeds, we believe it would be more than sufficient for that $100,000 delta to be covered by that proceeds.
All right, and so Mr. Harvey, can you help me with this? If the reason they don't have a lien on that is because the lessors of those leases haven't consented, and under non-bankruptcy law, the grant of a lien in the absence of the consent of the lessor is inadequate to create a security interest, is there authority that says under 364 I can override non-bankruptcy law and create a lien? And if so, what's the case?
We believe there is, Your Honor. I'd have to pull the case. It's a case out of, we actually litigated this issue in Blackhawk Mining in front of Judge Silverstein, another coal case here where I represented the ABL lender a few years ago. The way that she dealt with it, candidly, was to punt the issue and grant the lien to the extent it became relevant later. And so she did not decide it. There's a case out of the U.S. District Court for the Southern District of New York that approved using 365F and the anti-assignment, avoiding the anti-assignment provisions in that clause, overriding a consent to grant a lien release. I will tell you, Your Honor, that's not where we are today. That's what the lender, when they proposed what we believe a very onerous cash collateral order to us was. That's what they wanted. We're talking about proceeds on those leases, which does not require the consent, because it does not allow the landlord or the lender to step into the shoes of the tenant to perform the lease. It says, if things don't go as we planned, we think these leases have a value, because clearly they're extracting coal that our budget shows is being done profitably. And we're certainly not the only people in the world that can operate the coal mine profitably. In fact, the debtors say, or sorry, the debtors, Collins Street says we're the ones that can't do it. But when that lease gets sold, and we disagree with that, but when that lease gets sold, right, the proceeds, because clearly the debtor can sell that lease, notwithstanding the anti-assignment clauses. That's basic 365.
I understand that, right. That much I thought, and I wouldn't have, without having read any of the cases, I wouldn't have thought that would authorize me to grant a lien that non-bankruptcy law didn't otherwise provide for, but I haven't read anything about that yet. So I
will be totally candid, Your Honor. There is very general case law, including the Third Circuit, that talks about the broad overriding of anti-assignment clauses under 365F. There is, I think, maybe as far as more of one case from 1995 out of the United States District Court, and I can get that, have my colleagues get that case for if you want. It's cited in the Blackhawk Mining briefing, granting over the objection of the lessor a lien directly on the lease. I've also seen cases where liens have been granted on the ability of the debtor to sell the lease, effectively on the debtor's rights.
So I hear you. And look, I think as a practical matter, the point you make about the proceeds probably gets me through today. But I appreciate the candor and the thoughtful answer to the question. But I think, and they're interesting questions, but I think it's unlikely I'm going to conclude the facts are such that I need to resolve those legal questions in order to make a decision today.
Okay, Your Honor. So I've discussed at length, and probably more than you wanted to hear, why we think that the scope of the cash collateral, to the extent anything's been proven through the indirect evidence of our witnesses, including their reservation of rights. We try to make clear in our declaration, really for informational purposes, this is what people are alleging. Why the scope of cash collateral here is either very narrow or non-existent, because it just simply hasn't been proven. But what we tried to do, Your Honor, Dave, is come in and make a record, assuming that Mr. Lucas might surprise us and try to make a record, which he didn't, through his own evidence of the existence, priority, and validity of a lien that was entitled to protection. But let's put all of that aside. What did the evidence show as to diminution or adequate protection? 2 weeks. We're looking at 2 weeks. We start with 1.7 million. We end with, and hold on, Your Honor, I need to get the budget in front of me and give it to one of my colleagues.
Hold on, I also have that handy.
Yeah, I actually have a paper copy, Your Honor, because pretty old-fashioned. We show high level. We start with 1.73 million. We end with close to 4.3 million.
Hold on, bear with me. Let me. I just want to get it in front of me. So, okay, so I'm now looking at the budget that is attached to the end of the proposed order.
Right,
and I see it shows a beginning.
It's a little odd, Your Honor. I mean, again.
I see, but it has an ending cash balance of almost $4.3 million. That's the punchline.
And the beginning cash is right to the left of that one line up.
Right, because it's the beginning of that week. Right, so it's the beginning of week 1 to the end of week 2.
Yeah, and I think that's actually testimony was that 1.7 is the beginning of the filing the case, which was Tuesday. So essentially it is the end of the week, but a little bit typical. And then we have a 4.2. So there's, looking strictly at cash, clearly no diminution in value. I guess the best argument that the lender could come up with is, well, you're burning through coal in the mines to get there, and it's a finite resources that is all affect most commodities, not all commodities are, but many commodities, particularly fossil fuel commodities. You're burning through that, but you heard testimony that that's negligible, and that makes a lot of sense, particularly when, I think it was Mr. Ronke who said, even at the, and I don't recall if it was New Elk or if it was a Black Warrior, that you're talking 6, 7, 8 years left of coal, so 2 weeks worth of mining, not really going to make a material difference. So that's, again, assuming that they had that lien and that this is proceeds of their lien. If we assume all that, so we're trying to assume that they're right on everything that they haven't proven, you get there. And then for good measure, we try to keep this as skinny as possible. If you look at the next pages, we're representing prepay here, really the stuff to keep the lights on. So our interest here is in getting through next week, Your Honor, because we were forced into this situation, as we said in our papers, against our will, without any planning. We want to keep the lights on. We want to pay employees, which, regardless of what we do, is the right thing to do. And then we want to sit down with despite the animosity that's been here, we want to sit down with Collins Street, we want to sit down with our stakeholders, and we want to get them on board with a value-maximizing transaction and show them how we get here. We don't get out of the gate unless we get through this next week. And candidly, we'll be back next week, hopefully on a consensual basis, or at least on a less contested basis, going for more. That's why we thought it was important to show the 15 weeks, so that people didn't look at this 2 weeks and say, well, this is a bridge to nowhere because you can't show me that.
No, I understand why you did that. That was the right thing to do, because that's the question that I certainly, whether raised or not, I would have had. So I appreciate its role. I appreciate that I don't need to resolve the question of are they adequately protected for 15 weeks. I've got to answer the question, are they protected for 2 weeks? But I'm sorry?
I would say, to give you comfort, Your Honor, and so my first point was the 363P. My second point here is there really is no diminution in value to adequately protect to start with, because we start with the 15-week period, we're going to look out there. We look here, it's a 2.5 million, if my math is right, increase in value. If you run out a 15-week period, it's a $3 million. It's a negative hit to the assets that are in, or sorry, a negligible hit, a minimus hit to the assets on the ground. So there's nothing here that shows there's even likely to be a diminution in value. And then I get to the third point. If there is.
So I'm sorry, Mr. Harvey. Can I I just want to make sure I've got the parts right in my head. I understand that if you took the view that you ascribed to Judge Sanchi, that sort of treats cash collateral as an aggregate group, that there would be no diminution of value. But it is the case that under this budget, right, over the course of this 2-week period, you've got $4.5 million of cash that goes out the door, right? It gets replaced by, $7 million of new cash. But if one took a more granular view about the entitlement of adequate protection, wouldn't you conclude that the $4.5 million of cash that goes out the door is diminution, or do I just wrap my brain around that the wrong way?
I actually used the case in front of Judge Sanchi. It was a dairy case as an illustration. You take the view that it's cash in the till, it's getting cash in the till at the end. But if you say, I have a lien on all working capital assets and this is a fresh dairy company, you could take the view that, well, if I consume 100, again, you need 363E relief to get protection of any non-cash collateral assets. That is required, a request describing. We're required to offer it to the extent it's been proven it is valid in order to use the cash collateral, cash being the ultimate collateral. So if you say, I'm going to burn through $100 million of working capital assets for an ABL lender during the interim cash collateral, final cash collateral period, and all of that represents proceeds of my working capital assets, you're building a cash balance that entire way. But you don't have to adequately protect cash with cash. You can adequately protect cash with other assets.
Right.
So as long as Gordon Dairy, I'm picking on them because this was a case it came up in, takes that $100 million and it converts it into $102 million, $105 million, whatever you determine is an adequate position, there has been no aggregate diminution in the value of the cash collateral that existed.
I see what you're saying. You're saying that even if there's been an aggregate diminution of value of all of the collateral, there hasn't been an aggregate diminution of the cash collateral. And as to the diminution of the non-cash collateral, it's the burden of the protected party to under 363E to come in and show something, and that hasn't happened here.
Yeah, Your Honor, that's actually Judge Sanchi's view of Gordon Dairy and Exide. I'm saying that even if you take the contrary view, that as everything's converted into cash, you build a bigger cash balance, and as it's spent, well, every dollar that got converted into cash grows the cash that's entitled to adequate protection. Is that cash is then in an operating business being used to acquire new raw materials, turn it into WIP, turn it into inventory, sell it, generate AR. As long as that cycle of working capital is accretive at the end, because as long as they're getting a replacement lien and all of those proceeds, which they should be if they have a proper 552B argument, there is no diminution at the end of the process. It's only if for every dollar they're spending, they're getting back 97 cents that it is even a problem to begin with.
Right, okay.
I'd say this is the view in a value of accretive exercise, which is what the testimony was today, there isn't a diminution in that.
Okay, I understand your position.
And then, so the final thing I would say is, on that point, is there was also testimony that the book value of the assets, I'm going to get this wrong, Your Honor, that's one of my colleagues, sorry, my notes are everywhere. The book value of the assets of the Black Warrior mine was $16 million. The book value of the NECC mine is $43 million. Mr. Romkey's valuation of the Telqua mine or mine opportunity is over $20 million, I believe he said.
I'm sorry, was that, the last one you mentioned, was that an asset of the U.S. debtor?
It's an asset of goes to the total collateral package of Collins. Collins has a claims and has a lien at the Australian entity, parent company, which itself has 4.3 Australian, I believe, in
I see, and because that's that secures the loan that's at issue, even if it's even if it's not a debtor asset, it still bears on whether there's a diminution of their collateral.
Correct. Your Honor, if someone has a $30 million loan and they have $100 million of non-debtor collateral to look to, it's a little unfair for them to say that I'm inadequately protected. It's like having a parent guarantee.
No, I understand the point.
So there's 16 million at BWM, 43 million at BWM Blackwater Minerals, 43 million at the New England, New Elk, a coal company in Colorado, approximately 20 million at South Law. And I'll let Mr. Lucas speak to this if he wants to claim his client doesn't have a lien on that. I believe they do not have a direct lien on the assets at South Law, but they claim to have a lien on the equity interest in that. My understanding is that company does not have material liability, so that's effectively a lien on those assets. I'm not great at math, Your Honor, but I add up all of those things, and it's double what the $30 million, more than double what the $30 million Collins estimates that it is owed. So just on that alone, I think you could ascribe value that they have in substantial equity cushion. So I think that there's sort of no diminution in value. There's adequate protection through their equity cushion. But if all else of that fails, we've got a substantial mine, a lease for a mine in Alabama. We've got a substantial lease for a mine in Colorado. Uncontroverted evidence that they don't have a lien in those things. And we will offer them a lien in those to the extent of the diminution in their value. So that's how we think we get there, Your Honor. On the 363 point, on the fact that there is no diminution, on the existence of an equity cushion through all of these buckets of collateral that they have access to. And if all else fails, they will get these mineral lease, the limited interest in the proceeds of the mineral lease. And what we're really talking about, Your Honor, is getting here. And honestly, this is why we were puzzled by their declaration of default. We think they are oversecured, and I'm not trying to pass aspersions for the purpose of doing it. We think this was precipitous action to force early payment. And frankly, their loan document is something you've probably never seen in U.S. loan documents. They don't just charge default interest from the date they declare default.
So you said it's retroactive to the beginning.
So they goose up their claim, and then they can try to get payment more promptly than they otherwise would. However, it's purposely to the detriment of others. We don't need to get into that today, Your Honor, because you might be just sitting there, well, why is it in their interest that they have all of this collateral? We're a little puzzled by that, too. We thought we were working in big with them. We were talking to investment bankers at their direction. We got a notice of a default to the lease, which we promptly cured over the weekend. We sent it to them. They were unhappy with letting the $1 million go out the door that needed to be to cure that. And they delivered the notice of default and refused to withdraw it. And that forced us to file. And I think that was their intended effect. But, actions have consequences. We're here now. The consequence of that is they cut off their 552A lien, and they can't prove today, which they haven't, that they don't have liens on these other things. I think it's a pretty easy case, Your Honor, and we're talking about 2 weeks to keep the lights on. Make sure employees, who shouldn't be lost on the court, did work pre-petition to generate the receivables that Collins now wants the estate to collect for their benefit. We think it's a pretty up and down case. We think the evidence, to the extent it's relevant, is uncontroverted. And we think the court can grant it and should grant it so we can make payroll. And our goal, despite all the water under the bridge that's happened here, is to engage with Collins, engage with all of our stakeholders, find a path forward, and really try to reorganize these companies because, and I'm sorry to backtrack, I'll just address one point. I think testimony on this was, this company was a loss-making enterprise, but you heard that they tried for 6 months to do thermal coal. That was logical, Your Honor. And about a year ago today, Ukraine was invaded by Russia. You saw all the news about natural gas being cut off. A lot of these power plants in Europe can use both natural gas and coal. Everyone started putting liquefied natural gas in Europe. but there's terminals we built into that. Coal's going into, well, then you have a massive amount more of liquefied natural gas going into Europe than was expected, an extremely mild winter, and alternative sources, and that dropped the price of thermal coal. So the company made a strategic business decision to get into the thermal coal market more heavily. They were doing met coal before that, went into thermal coal based on geopolitical events. It didn't work out, right? And so they switched back to metallurgical coal, which has, as you heard testimony today, is a much more robust market, a much scarcer resource, and it's commanding a higher price. So I don't think that there's any nefarious explanation for why the company's projections in the past didn't work. Every company that comes before you, Your Honor, has projections that didn't work. The benefit here is we're not paying legacy liabilities, we're paying necessary go-forward liabilities. We are trying to turn around the operations. We think we can do it while adequately protecting whatever the lender enters interest in. We may need debt financing. We're not there yet. We will, I think, retain an investment banker and pursue a sale. But we don't get to any of that if we don't get out of today. And I think the alternative to getting out of today is we'll have to take a break, Your Honor. And it might be Collins Street to get what they want. And they're the proud new owner of 2 holes in the ground with no one to mine them. That's all I have, Your Honor, unless you have questions.
No, Mr. Harvey, that was quite helpful. I appreciate it. I'm happy to hear from the other side. Mr. Lucas.
Good afternoon, Your Honor. John Lucas, Michalski staying for Collins Street. Your Honor, we're here today because the debtor is asking for authorization to use Collins Street's cash collateral. Had there not been a dispute about cash collateral, I don't think the debtors would have filed a motion. And this isn't a hearing where the court is making a determination about the liens, interest, and priority of Collins Street's claims, which is something that's ordinarily done pursuant to an adversary proceeding under Rules of 7001. And as Your Honor acknowledged, through the declarations and also in the motion, the debtor acknowledges that Collins Street has blanket liens on substantially all the assets of the operating debtors. Your Honor asked at the outset of the hearing is, what are the unencumbered assets and what value do they have and what is the replacement lien on? It's our view that the replacement lien is just on exactly what we already have. It's unclear whether or not the debtor can without notice and without the consent of the property owner of the land, grant a lien, a replacement lien to the extent of any diminution in favor of Collins Street here with respect to the use of cash collateral.
No, but what about the proceeds? What if I conclude that it's disputed whether the proceeds from those 2 mines are within or without your collateral base, and that you've not sought adequate protection under 363E or met your burden under 363P? Why can't a replacement lien on the proceeds from those mines, to the extent the mines to the extent there's a issue with respect to the lien on those mines, why can't right? I mean, I'm assuming for this purpose, and if you disagree, you should tell me. But good luck. That if you don't have a lien on the mines, you don't have a lien on the proceeds of the mines, and so why can't a replacement lien on the proceeds be sufficient adequate protection to the extent you have an interest to which that entitles you to adequate protection?
Can I ask just one question to make sure I understand?
Absolutely.
I believe Your Honor is asking if Collins Street doesn't have a lien on this subject lease.
Right.
Then obviously Collins Street doesn't have a lien on the proceeds.
Right.
And then the ultimate question I believe you have is, can't the court grant a lien, not on the lease, but on the proceeds? Correct, Your Honor?
Correct, as adequate protection to the extent, right? Because what the debtor says, look, there's not going to be any diminution of your cash collateral, so you don't even get to this. But to the extent your cash collateral is diminished, we can give you a lien on the proceeds from those leases, and that's adequate protection.
Your Honor, I do not dispute that to the extent that the proceeds that flow from the lease, that I believe that we could get a lien on it, provided, however, that assumes that the lessee doesn't also have security interest rights with respect to the materials that flow from the lease.
All right, well, the lessee hasn't come here to make that suggestion to me.
Understood, Your Honor. Your Honor, we're here today, and I think that the record demonstrates that the historical performance of the debtor has been less than wonderful. Your Honor, both the CFO and the CEO of the debtors acknowledged that the debtors had been unable to generate cash flow positive operating companies for at least the past 6 months. And that for every cash forecast that was acknowledged, that was sent to Collins Street prior to the petition date, they were all on a negative cash flow basis. And then, Your Honor, suddenly over the past 2 days, the debtor has a cash forecast that is, we prefer Your Honor's term, much like a hockey stick. Your Honor, the cash forecasts are speculative at best, and they rely wholly on the fact that the debtor is actually going to have the coal receipts, the coal sales that are projected in here. There is a nearly 14-time increase in the coal sales between this week and next week, Your Honor. And there's no real explanation for the difference in the coal sales. Your Honor,
So, Mr. Lucas, if I thought that on balance the debtors have made a sufficient showing to get to March 3rd, and it turned out on March 3rd that you were right, you would still have the adequate protection that we just talked about, and a really good argument that I shouldn't believe them, because I would have believed them and you would have shown that they were wrong. And so as I look at the whole record in front of me, why isn't that a sensible thing to do?
Because, Your Honor, we believe that the cash here is such a precious resource that we do believe that the 2 weeks is really sort of a bridge to nowhere. In the record, Your Honor, if you look at the New Wealth budget for the 15-week cash flow, which is in the record, all of the sale projections that are in there for the receipts are all speculative. There is nearly $2 million every other week, beginning in week 4, Your Honor, through the end of the term, where it is completely speculative. The debtors don't have it, prospective purchasers, and there's no real sort of forecast or history to back up that they can meet those sale objectives. Similarly, Your Honor, the Black Warrior one, it's the same, and actually it's even worse. The prospective sales for the end of next week for just Black Warrior are nearly $2 million. And they go on. Next week, 1.3, 680 million goes thrown out. Week 8, 2.6 million. And again, Your Honor, these are projections that have gone unperformed in the past, and we have no reason to believe that the future is going to be any different. And so to the reason why we believe it's important is just to take the cash now and to freeze the assets, to preserve the assets so that they could be taken and marketed and sold to a prospective purchaser.
Okay, I understand your position.
Yeah, and Your Honor, we don't believe that the debtor has much faith in its budgets, Your Honor. The debtor is out looking for debtor in possession financing.
Yeah, so Mr. Lucas, I understood that, and I understood the point Mr. Litvak was making on examination about that, but I mean, look, is there anything less surprising than the notion that the debtor would give its best projections and in the event it turns out to be wrong, be prepared to, have some cushion in the event it's wrong? I mean, have you ever seen a case where someone hasn't done that?
Your Honor, the cushion here is really just speculative. And I think that in cases where you have cushion, you have real cash, you have real customers, and you have real prospects.
I understand that. And Mr. Lucas, look, to the extent they come in with a dip that tries to prime you over your objection, I'd have to sort through that, right? So I'm not saying now that they can further encumber, the assets that secure the loans you've made with new debt that primes you. We'd have to do a deeper dive into that. So I understand that point, but that's a different point from saying the fact that they're looking is conclusive evidence that they know their projections are wrong.
Thank you. I understood, Your Honor.
Okay. Is there anything else I should understand?
I'm just looking through my notes, Your Honor. And Your Honor, the remarks about the value of the New Wealth mine at $43.6 million and the Black Warrior mine at approximately $16 million. I mean, these are book values, Your Honor.
I understand that. I understand that.
The market cap for these companies is together is maybe $13 million, and the stock is trading in pennies, Your Honor. And the stock has a precipitous drop in the past 6 months.
Well, of course, the company's got $50 million of unsecured debt. That would affect the equity value, right? That wouldn't tell us about the value of the collateral, right?
Yes, Your Honor. And Your Honor, Your Honor, so the debtor here is sort of lays at stake and about its future of transitioning from thermal to coke. And Your Honor, they admit today that they've been doing this for 2 weeks. A 2-week track record here, Your Honor, without any sales that are confirmed and binding and that are going to generate the cash that is projected in the cash forecast, we think is beyond speculation and is going to result in substantial losses going forward, which is going to end up fall on the shoulders of Collins Street, Your Honor. As the debtors have acknowledged, and what we think is very important, is that a marketing process and a sale process is commenced immediately, and we think that's where the resources would be better used if the debtor engaged a financial advisor to help the CFO and the CEO sort of figure out about what the best sort of format for the projections are going forward, and also an investment banker so they could figure out sort of what interest there are for these assets, as Collins Street has been urging the company, the debtors here, to engage both of those because it was important to do any out-of-court workout parallel alongside with the workout with where we are now, which hasn't been done.
So, Mr. Lucas, can I understand because look, I understand the arguments you're making. They're sensible arguments. You're basically saying, look, we think we're the fulcrum security, and we think, frankly, this asset is worth more dead than alive, and every day it's alive comes out of our skin, and you're spending our money and stop. I understand that position. If I think, nevertheless, that the debtor has technically met its showing to use cash collateral for the next 2 weeks, there's then the question of, do we continue? Well, look, let me say this. Let me think about. I will think about this and rule the way I think the law and the evidence points me. I guess all I'm thinking out loud, so apologies to everyone for having to listen to me muse, but there does seem to be some tension between your saying on the one hand, the bankruptcy process is really expensive and you haven't taken account of the administrative burn of the bankruptcy case in your budget, and therefore we think your use of cash collateral is going to be far more extensive than you've said, and therefore we're not getting adequate protection, so the case should be shut down immediately. And you need to go get a world-class investment banker to run a top-notch marketing process. And at some level, we've got to kind of figure out where we are, but I think I've answered my own question by saying, why don't we do this one step at a time, and I should resolve the question in front of me, and then let you all talk and figure out where you are thereafter. And if the next question is presented, I'll address it if and when it's presented. So thank you all for listening to me muse. But that I think is probably the path through this. Mr. Lucas, is there anything else that I should know and understand with respect to the question that is in front of me today?
No, Your Honor, unless you have any more questions for me.
No, I appreciate your position, and this has been very well presented. I appreciate that life is short and there's a need to get a ruling and proceed, because there's a lot of work to do however I come out. So but I do need 5 minutes. So I'm going to take 5 minutes. You go ahead. Certainly.
I apologize.
No, go ahead.
If I was just forming a thought, if Your Honor rules that the debtor can use cash collateral, and as part of the adequate protection, we get replacement liens. We should get replacement liens on all unencumbered assets, not just the proceeds of the mineral leases.
So let's look at the order that they're asking me to enter.
So, Your Honor, if you look at paragraph 3.
Yeah, 3A, and you're asking for,
Sorry.
So you think that 3A shouldn't be just on the proceeds of the mineral leases. You should say it should say and on any other unencumbered assets
Of the debtors.
of the debtors.
And the proceeds thereof of those, correct.
Okay, Mr. Harvey, let me bring you back. And actually, before you do that, Mr. Lucas, you agree with the limitation, of course, which is solely to the extent of the post-petition diminution of value of your interest in the cash collateral. That's what you're entitled to adequate protection of, right?
Yes, sir.
Okay, so, Mr. Harvey, to the extent I'm with you on the other points, what's the harm in saying, look, they get, as adequate protection, replacement liens on what you've identified and anything else that turns out to be unencumbered?
1 second, Your Honor.
And Your Honor, to make it a little easier here, we're not trying to be overreaching here to get liens on avoidance actions. Not asking that.
On assets, right, property of the estate, as of the petition date. I understand that. And it's again, it's only to the extent that you are able to show a diminution in the value of your collateral as of the petition date. Mr. Harvey?
I think that's right. What the request today is to use cash collateral. They send them any diminution in cash collateral based on the use, sale, or lease of that cash collateral, a lien, and replacement lien on the debtor's other assets, I think is appropriate, Your Honor, in these circumstances, if that's what's required to get it over the finish line. You asked about any concerns. The only concern I can think of, I don't have on my top of my head, and I don't want to delay things, is whether we get into any sort of marshaling aspect where they've got $1 million deficiency claim and they go after something in a fire sale that's $3 million.
Let me tell you, everyone's rights would be reserved on that, and we would sort that out if we'd cross that bridge if we got there.
I assume Mr. Lucas and his client will act in good faith on that anyway. So,
Right, and if they weren't, I have the authority to address it. So I understand your concern. It's a fair point to raise, but I don't think that ought to get in the way if that's the issue. Okay, I think I just need 5 minutes to collect my thoughts a little bit. And I don't want to take too long, but would it make anyone crazy if we recessed briefly and came back on at 5 of?
that works for the debtors, Your Honor.
It's fine, of course, Your Honor.
Okay, I appreciate that. So we stand in recess. I'll be back on at 5 of. Thank you. Okay, this is Judge Goldblatt. We are back on. Let me first, I appreciate that this hearing was conducted, in extremely expedited terms, and that no one had the opportunity to prepare the way they normally would. Nevertheless, let me commend counsel on both sides. I think this was exceptionally well presented under the circumstances all around. So, Mr. Lucas, your hand is up. Let me give you a chance to talk before I blather.
Thank you, Your Honor. I got you for the blather. I just wanted to clarify one thing I said at the end of the hearing there, because I think we could all sort of see where this is going in one way. That as for the replacement liens, Your Honor, obviously the proceeds of the mineral leases is one thing, and then the replacement lien should be on all assets. And I think I said that. I'm not sure.
I think you did. Look, we'll get there. Let me just give my reasons just so that I have a record, and I do this by the book, and then we can talk about the fine points, though I appreciate that. I often say I describe my terrible poker face as the virtue of transparency. So look, here again, I do want to commend counsel on both sides. This was for something that happened so quickly, done exceptionally well. I think Mr. Harvey's correct that the relevant statutory provisions are sections 363A, C, and P, and what my conclusions based on, or the findings based on the evidence that I heard, is that I'm going to grant the motion, and we're going to talk about the specifics of the order, but the basic rationale is the debtors made an argument that about there being no diminution of cash at all. That may or may not be right in terms of it's a prediction about the future, as these things always are. I'm persuaded that it appears to be in good faith, which doesn't mean that it's going to be correct. I do believe, though, that the question about the validity or even existence of the lien on the two of the mines, and therefore on the proceeds of those mines, has not been met. And so, therefore, even if it turns out there's a diminution of cash, it seems to me for at least the short period that we're talking about, there's the ability to provide adequate protection. So my ruling is going to be, as you predicted, that I'm going to grant the motion, and that we just have to talk about the form of words about what the adequate protection lien is in. But I'm inclined to think that whatever is unencumbered and available to provide adequate protection without priming somebody else or leaning up something that isn't property of the estate ought to be available to the extent of the diminution of the value of the cash collateral over the period of time for which its use is authorized. And then we're going to be back here reasonably soon, and we can talk about when. And, the use of cash collateral for this period isn't going to solve all the debtors' problems. You obviously, as you all recognize, need to talk. This won't surprise anyone either, but in the event you don't reach an agreement and we're asking for further non-consensual use of cash collateral, certainly what happens, whether you were right or wrong about your optimistic budget for this period, will inform how I think about the reliance on the debtors' projections, in the event we find ourselves in that position. I hope that doesn't surprise anybody. So that's where we are. So I think we next presumably have what is a wordsmithing issue with respect to paragraph 3A of the proposed order. And my guess is that Mr. Harvey now has language he wants to tell me he's going to propose.
I've very little time to look at it, Your Honor, so I wasn't sure you would go that far. Thank you, Your Honor, though, for your ruling. I think it's 3A, and I think we can get it as simple as saying replacement liens, unless my colleagues jump up and down and tell me I'm wrong. Replacement liens, because it's defined only to the extent of diminution in value on all unencumbered assets of the debtors, and leave it at that.
It should be all assets, Your Honor.
No, but Mr. Lucas, if I were to say that, that would at least create the suggestion that I'm allowing you to prime somebody else. And I don't think, you get super priority and all of that under 364, but you don't prime another lien.
Your Honor, understood. I think what I'm saying is, I'm saying.
Your Honor, if I can chime in on this.
Sure.
For a moment.
Sure.
I think what we typically get, Your Honor, these types of financing orders is you get a lien, an adequate protection lien on all assets except for the proceeds of avoidance actions, which is fine. Avoidance actions are the proceeds of avoidance actions pending entry of the final order, and any permitted liens. And there's usually like a standard, definition of what a permitted lien is. It's basically other, prior perfected liens.
Okay, and when that's negotiated between the new lender and the junior lenders, that's fine, but I don't have that here. And so I think it's going to be on unencumbered assets, which in theory ought to be the same as what you're saying. So I think the words unencumbered assets is more appropriate in these circumstances. So 3A of the order should say replacement liens.
Actually, I think we should change it to on the proceeds of the debtors' mineral leases and any unencumbered assets. And the thing I'm hesitant about is saying all unencumbered assets is, well, the debtors' leasehold interests are unencumbered, but as you recognize, no one's here to dispute it today, but maybe on the leaseholds themselves, there might be an issue there. So it could be as simple as all unencumbered assets.
That's fine.
Yeah.
Okay. That's so Mr. Harvey, why don't you read 3A as you would propose it appear in the order that I'm going to sign?
Replacement liens, I'm eliding the parenthetical there, but that just contains definitions.
Yep.
Replacement liens on all unencumbered collateral of the debtors. Maybe the way to deal with this is to the extent that
I think unencumbered collateral is an oxymoron.
Unencumbered property, sorry. Unencumbered property of the debtors, unencumbered assets of the debtors, other than to the extent that consent of a third party is required.
So I'm comfortable with the language, having it read on all of the debtors' unencumbered assets. Because to me, as I think about the principle under which, non-bankruptcy law wouldn't permit you to lien up a lease without the consent of the lessor. I think the notion there is it's a restriction on what was your property to lien up. And so I think it's not inconsistent then with that principle to say on all of the debtors' unencumbered assets.
Okay, and I think the Collins was okay with a carve out for we don't have a committee in this case yet, at least pending some further order of the court, proceeds on void seconds. So I just asked them to confirm that.
Yes, Your Honor.
Okay. Okay. So I'll enter an order so providing. Where to from here, Mr. Harvey?
I think this is the part of the hearing that you mercifully get to stop hearing from me, Your Honor. And you can hear from some of my more able colleagues, particularly Ms. Hopper, who will walk through the remainder of the agenda.
Okay.
Your Honor, I have one question before Mr. Harvey.
Certainly.
I'm not clear on what the process is going forward. I obviously understand there's going to be a revised order. Mr. Harvey will share it with us. He'll submit it to Chambers, and we're on our way with respect to that. But this is an interim order, and it is for 2 weeks. So the question is, when is the court going to be available for the next hearing, and when are the debtors going to?
Get something. That's a totally fair question.
Or something about where we're going to deal with this in the event that things aren't worked out, or
Totally fair and good question. That's something I was going to raise later, but this is as good a time as any. Look, this authorizes the use of cash collateral through March 3rd. I am free the afternoon of March 3rd. And in terms of, when a motion would need to be filed and the like, I guess I would propose that the parties talk about that in the first instance before I just go setting deadlines for folks. But is there any reason we can't hold the afternoon of March 3rd for a further hearing if one is necessary in this case?
Your Honor, that would force the debtors, at least in respect of cash collateral, I believe, because the cash collateral authorization today would cover payroll for next week. In our case and our desire to do is, I guess, to ask for as little as possible if necessary. We asked in our payroll motion for what's being done this week. So there will be a further payroll motion some point tomorrow or the weekend or next week. And it's not all secret what that's going to ask for. It's in the budget. It's what's in the budget. So we will ask for that. If we have Mr. Lucas's agreement, I'm sure we can get Mr. Fox on board. It may be that that even comes under certification at council, whether because it's part of the already approved cash collateral or a broader agreement with them. We'll also at some point have things in the nature of utilities, taxes, insurance, things like that. We're still evaluating what we need.
Mm-hmm.
We need interim relief on that next week in advance of Friday. So there's a long-winded way of saying, Your Honor, I think we can hold that date, but we need to caucus internally. We certainly need to caucus with Mr. Lucas and his client. And if there isn't a deal forward, we'll need to talk to them about, getting all of their loan documents, all their valuations, everything like that, so that we can come back on a more fulsome contested cash collateral. But I think rather than waste the court's time with that, let's hold that date you have for us, at least for further use of cash collateral. We'll talk to Mr. Lucas about timing, filing papers, and hopefully we'll reach agreement on everything. We'll all be coming back singing Kumbaya at the next hearing. Or at a minimum, we'll have a better sense of the lay of the land and what's contested in front of Your Honor, and the best way to go forward on that.
Mr. Lucas, any objection to proceeding that way?
I guess, Your Honor, I pause. I certainly want to try to work things out with Mr. Harvey and his client. I guess I'm just paused because, everybody just sort of went through sort of a lightning sort of hearing with the pleading file just before midnight, and we're here less than 12 hours before. My hesitation and my pause is because I think it's good for us to map things out, to have something in the order, to set deadlines for parties to present whatever it is that they're going to present, because, while I hope that the debtor's cash forecast is positive and it brings us in the right direction, in the event it's not, then we need to have something, a process.
Right. So, Mr. Lucas, here's what I suggest. I think everyone agrees we should have a rational process. I propose that you talk in the first instance. See if you can agree on a rational process. If you can, write it down and I'll sign it. If you can't, reach out to Chambers and we'll get on a Zoom call and we'll figure it out.
Thank you.
Okay.
Yeah, I think you're right. What I would suggest is we use at a minimum today and tomorrow, and then we'll bother you by Monday if we haven't been there, and then the full 5 business days from Friday. I'm confident we'll get there, at least on a process, if not on the substance.
Okay, well, why don't you make your best efforts at that? And if that fails and I have a dispute to resolve, I did sign up for a job that involves resolving disputes.
And you're very good at it, Your Honor.
Well, you and my mother think that.
Thank you, Your Honor. With that, I'll see I guess, physical virtual lectern here to Ms. Topper, who can walk through, but hopefully should be uncontroversial remaining first aid level.
Very well. Ms. Topper.
Your Honor, I'm sorry to interrupt.
You look nothing like Ms. Topper.
Yeah, no, I apologize, because your report for the record may be excused.
Certainly.
Thank you.
Ms.
Good
Topper.
afternoon, Your Honor. For the record, Paige Topper, on behalf of the debtors in these Chapter 11 cases, Your Honor, I am going to cover very briefly the last 2 items on today's agenda. It's the item number 4. We'll just take them in order. Item number 4 on the agenda is the wages motion. It's filed at docket item number 6. Your Honor, through this motion, the debtors are requesting authority to pay or otherwise honor the debtors' pre-petition obligations for both their employees and independent contractors in a capped amount not to exceed $645,000. This is really, as stated in the motion, Your Honor, the bare minimum relief, as Mr. Harvey mentioned, to meet the payroll that is for tomorrow for the mine with Newell Coal Company. Your Honor, I will say we did file a certification of counsel. We received some minor comments from the Office of the United States Trustee. I'm happy to walk through them if you have any questions, but otherwise, we would request an entry of the order.
Mr. Fox, welcome back.
I made it just in time to say that debtors' counsel's representations are correct. My office's informal comments have been resolved, and we have no objection to entry of the form of order.
Okay, so is anyone else like to be heard with respect to the debtor's wages motion?
Your Honor, Collins Street is fine.
Okay, thank you very much. So I've reviewed the motion in order, including the certification and the red line. The court satisfied the relief sought is appropriate, and we will enter that order.
Great, thank you, Your Honor, and I have confirmed that that order has been uploaded.
Okay, we will enter that promptly.
The final item on today's agenda, Your Honor, is item 5. It is the cash management motion. It was filed at docket item number 8. Your Honor, as detailed in this motion, the debtor does have 7 bank accounts at 3 different banks. They have essentially 2 separate accounts at both their operating companies, as well as an intermediary account at debtor Allegiance Coal USA Limited. And that account deals with sort of intercompany transfers between the 2 operating companies as well as with non-debtor affiliates. We are requesting pretty customary relief pursuant to this motion in this interim order, Your Honor, including, among other things, to continue to operate both the cash management system as well as continue to use and maintain the existing bank accounts and business forms. Like the wages motion, Your Honor, we did receive comments from the U.S. Trustee. I do want to, since Mr. Fox is back on, I do want to thank his office for the very quick responses and working with us to resolve his comments ahead of today's hearing. The certification of counsel that incorporates the Office of the United States Trustee's comments in that proposed order was filed at docket item 22. I'm happy to walk through those comments or answer any questions that the court has.
No, I've reviewed it and don't have my own questions. Is there any other party in interest that would like to be heard with respect to the debtor's cash management motion? Okay, seeing no one, I'm satisfied the relief sought is appropriate under the circumstances, and we will enter that order.
Thank you, Your Honor. I'm going to see the podium over Mr. Harvey.
Okay, thank you. Mr. Harvey.
Thank you, Your Honor. Just an administrative matter on the order It wasn't clear to me on the cash collateral order. Obviously, it's very urgent for us, whether you had interlineated the changes and we're going to upload them, or you wanted us to. We've done it our end. We can circulate to Mr. Lucas. Hopefully, Ms. Hopper has circulated it already, so I guess maybe I'm up here talking for no reason. But as soon as they're signed off, we'd like to get uploaded. We were just checking on Your Honor's availability to sign an order tonight.
I fortunately have the assistance of the greatest staff anyone could ask for, and so we will be able to enter an order this evening as soon as the parties have agreed on it and it's been uploaded. So, Mr. Lucas, you're still reviewing it, or?
I just received it, Your Honor.
That's fair.
And I thought I was going to say both the proceeds of the mineral leases and all unencumbered assets. And it just says all unencumbered assets.
Is there any
I wasn't sent a black line. I was sent just a clean copy. So I was trying to compare and I was trying to listen here.
All right, everyone is.
I'm not trying to dig in my feet or anything like that. I just thought we were doing what was said at the hearing.
All right, look, everyone is working fast, and I'm satisfied in the best of faith. But, Mr. Harvey, is there any reason it can't say the mineral leases and any other unencumbered assets?
Proceeds of the mineral leases and other unencumbered assets.
Yeah.
We can do that. My reading was, Your Honor, the proceeds was consumed within that.
I think these are substantially the same, but if that would address a concern, I don't see any, and it doesn't do you any harm, I don't see why we don't make the change.
We're fine with that, and I hear Ms. Topper typing to my left.
Okay, so under the circumstances, can I ask that the parties talk and that I will treat someone uploading an order as a representation that that form of order is agreeable to both sides?
Yes, Your Honor.
Yes, Your Honor.
Okay, so we will, and let me ask this about timing. Is this something where getting it in the next half an hour makes a difference, or is given where we are in the business day, are we in a situation where as long as it happens tonight, it's all the same?
I think it's happening the sooner it can happen, Your Honor, make the chance that we can get it out to others. Mr. Ronke nodding.
Okay.
We actually get it out today. It goes out through the bank today, ends up in their accounts tomorrow.
Okay. So we will stick around for a half an hour or so. Why don't you endeavor to try to get it done in that time frame? If it's uploaded, then we'll do our best to get it entered.
We'll try to do it in 5 to 10 minutes, Your
Okay.
Honor.
Any other matter on which the court can be helpful to the parties today?
The debtor said nothing, Your Honor. Thank you.
Mr. Lucas, anything further?
No, Your Honor. Thank you for your time. We realize it's been a long hearing.
Okay, this is the job I signed up for. So let me again thank all of you. This has been helpful. We will get the orders entered as soon as they are uploaded, and I anticipate that this isn't the last time I'll hear from all of you. So I look forward to seeing you whenever I do. And with that,
Better circumstances.
the circumstances will be what they will be. With that, and with my thanks to everyone, we're adjourned. Thank you.